Over to you, Program Director.
Thank you, Mr. Mneti. Good morning, everyone. Good morning, everyone who's in attendance. Welcome to the Code of Conduct webinar. We will be taking you through the Code of Conduct. Welcome, everyone. We have the legal team as well as the Registrar of SACCUP here with us. This is the webinar of SACCUP for the Code of Conduct presented by the legal department. So my name is, yes, I should introduce myself. My name is Hello. My surname is Mashile. I will be your program director today. So you will be in my name. So what I'll be doing is that I will be directing the program, making sure that the panel that's supposed to be present on time and finish on time, as well as there will be question and answer as we go. And as you see on the program, hopefully we'll stick to time. Before we continue, we need to observe protocol. So I will welcome the registrar, Advocate Dr. Feduli, to do opening and welcome. Thank you.
Thank you very much, Ms. Mashile there, and greetings to all professionals who have joined us today. I see that professionals are still joining. I'm just going to delay a little bit so that the majority of them can come in, so that we can have a discussion on the code of conduct. Just a few seconds, just let's allow them to join, and then we can start. We can kick start with the webinar. All right, I think let's commence with the proceedings. I see there's a hand there from Johan Duplessis. You will get an opportunity to engage with the legal team once they've commenced with the presentations. But for now, I'm just going to welcome all of you today and indicate to you that this workshop is really for you to make sure that you understand the code of conduct, so that when you deal with members of the public, you are able to comply with the code of conduct. You'd have noted that we've been doing a lot of public awareness campaigns, and the objective there is to educate the public about the profession, so that they know that when they want to do any building, they are able to get somebody who's registered. So we will continue doing those public awareness campaign, so that the public are also well informed from their side when dealing with registered professionals. But today, the focus is on you. We've noted that there is a pattern in terms of the contravention that we receive. On average, every year, SACCUP receives about 170 or so complaints of improper conduct. And we can reduce that if all of us, we know the code of conduct, and we make sure that when we are dealing with clients and any other member of the public, we comply. And that's why today it's about making sure that there's a proper understanding of the code of conduct. We learn from each other. You can ask questions, engage the team. They will give you the type of complaints you receive, and then also suggest to you the best possible way to avoid contraventions of those sections of the code of conduct. So I'll end it here and hand over to the team to proceed with the actual contents of the code of conduct. And then you'll have an opportunity to ask questions, and then we'll be able to address all your questions. Thank you very much, Program Director.
Thank you, Registrar. Indeed, prevention is better than cure. So what we are going to do now, we are going to call our first speaker, Mr. Sfanele Matebula, to take us through the first rule of the Code of Conduct. When you look at the rules, it will look like we had picked, but they are not in a numerical order. The reason is because of the fact that we, as the registrar has said, we have looked at the most contravened rules in the code of conduct, hence the selection. So Mr. Matebola will be taking us through rule 1. Thank you. Over to you, Mr. Matebola.
Thank you, Program Director. Greetings to everyone. Protocols observed. My name is Sfanele Matebola. I am with SECAP. I am going to present on Rule 1 of the Code of Conduct for registered persons. We all know that Section 27 of the Architectural Professions Act of 2000 mandates SECAP to develop and draw a code of conduct for its registered persons. SECAP discharges this function by consulting the Council for the Built Environment, voluntary associations, and registered persons. All registered persons are therefore mandated to comply with the code. Failure by registered persons to comply may attract any of the sanctions under Section 32, subsection 3 of the Act. So, colleagues and fellow RPs, this part of the presentation will focus strictly on Rule 1, which is integrity of the Code of Conduct for registered persons. Rule 1 of the Code requires all registered persons to act and conduct themselves with integrity. The term integrity encompasses the quality of being honest, sincere, trustworthy, and generally having strong moral principles and ethics. Therefore, this rule places a duty on RPs to be transparent at all times when they carry out their professional duties and when dealing with members of the public. SECAP, as it has already been stated by the registrar and the program director, it often receives and investigates complaints against the RPs who are accused of receiving payment, but then they fail to render services for which they would have been paid. The most prevalent misdeed perpetuated by RPs is one where RPs conduct or conclude contracts with members of the public in terms of which they undertake to draw up building plans and submit them to the local authorities for approval. They then fail to honor their obligations in terms of the contract. Such conduct is then discouraged by SECAP as it borders closely on dishonesty and it is unethical. RPs are accordingly charged for improper conduct in terms of Section 29, and they are prosecuted before a disciplinary tribunal in terms of Section 31 of the Act. RPs found guilty of contravening any of the sub-rules under Rule 1 are accordingly sanctioned. Below are the sub-rules under Rule 1. So we have Rule 1.1, which states that RPs shall take into consideration the standard of honesty and integrity that underpin this code of conduct when performing architectural work. Colleagues, this sub-rule is general. An example of a contravention of this sub-rule is when an RP generally acts in an unethical manner that offends any rule of the code of conduct. This sub-rule sets out a standard that should be observed by RPs at all times. RPs should never deviate from the code when discharging their architectural functions. According to the SECAP sanction, guidelines, a contravention of this sub-rule attracts a sanction of a fine up to 20,000 rands. In cases of extreme indiscretions, the SECAP tribunal may order the suspension or cancellation of the registration of the RP. Rule 1.2 provides that RPs shall at all times act with honesty and integrity and avoid any action or situation which may be detrimental to the esteem and dignity of the profession or conduct which brings the profession into disrepute. An example of a contravention of this sub-rule is similar to the one provided under sub-rule 1.1 above. This sub-rule discourages RPs from engaging in conduct which may bring the profession into disrepute. According to SACEP sanction guidelines, a contravention of this sub-rule attracts a sanction of a fine between 15,000 rands and 20,000 rands. In cases of extreme indiscretions, the SACEP tribunal may order the suspension or cancellation of the registration of the RP. We move on to Rule 1.3, which provides as follows. RPs shall not make any statement which is contrary to their professional opinion, or which they know or ought to have known to be misleading, unfair to others, or discreditable to the profession. An example of a contravention of the sub-rule which has been received by SACEP is when RPs advise a client to build on unsuitable piece of land which occasionally floods, when in truth and in fact, the RP knows that such land is not suitable. This sub-rule requires RPs to provide professional opinions truthfully so as to protect their clients' interests. A contravention of this sub-rule attracts a sanction of a fine between 5,000 and 10,000 rands. Rule 1.4 provides that RPs shall not knowingly undertake work in circumstances or under conditions or terms that would compromise their ability to carry out their responsibilities and fulfill their commitments to their clients. So with regards to this rule, SACEP has received and investigated a case where an RP was diagnosed with an illness that rendered them incapable of discharging their functions. But the RP still accepted a mandate from the client. This sub-rule requires the RPs to avoid putting themselves in a situation where they will have their interests conflicting with those of their clients. In this scenario, the conflict that is manifested here is obviously the RP wanting to do the work to earn a living versus a member of the public expecting to receive services promptly and services that are in accordance with his instructions. So SACEP has developed a sanction guideline, and in terms of that guideline, if an RP is found guilty of contravening this sub-rule, a sanction of a fine of 7,000 rands to 15,000 rands may be meted out to such an RP. Colleagues, we move to Rule 1.5, which provides that RPs shall not misrepresent or knowingly permit misrepresentation of their own or any other person's academic or professional qualifications or competency, nor exaggerate their degree of responsibility for any architectural work. SACEP has received and investigated a case where an RP used another professional's stamps on its documents, creating the impression that her work was confirmed to be in good order. The stamps were copied from previous documents and pasted on the current forms without the knowledge and consent of the other professional. So this sub-rule requires RPs to do work within their scope of qualifications. A contravention of this sub-rule will attract a sanction of a fine between 5,000 and 10,000 rands. Rule 1.6 provides that RPs shall not negligently issue any certificate in connection with any building project on which they are professionally engaged in. SACEP has received and investigated a case where an RP drew up plans for her client. The builder failed to build the structure in terms of the plan, but then the RP signed off some documents, even though the house was not built as per plan. A year later, an as-built plan was drawn up and the RP failed to update her calculations from the initial plan to the as-built plan. This sub-rule basically sets out a standard that should be observed by RPs at all times. RPs should never deviate from the code. Oh, sorry, my colleagues. This sub-rule requires RPs to act with due care and diligence, and they must satisfy themselves that the building project they are engaged in is up to standard and as per plan before they can issue any certificate to that effect. A contravention of this sub-rule will attract a sanction of a fine of 5,000 rands and 10,000 rands. We move on to Rule 1.7, which provides that RPs shall notify council without delay if they become subject to any disqualification as contemplated in Section 19, subsection 3 of the Act, as failure to do so may be deemed by council as improper conduct. So examples of factors that may render an RP to be unfit include being removed from a position of trust due to misconduct and being convicted of a criminal offense where the sentence is imprisonment without the option of a fine. An RP will be unfit to practice where the offense he is convicted of involves an element of dishonesty, like fraud, and the sentence is a fine or imprisonment or both. So this sub-rule requires RPs to promptly report to SECAP if any of their circumstances change that could render them not to be fit and proper to practice architectural work. A contravention of this sub-rule attracts a fine of between 5,000 and 10,000 rands. Rule 1.8 provides that the RPs shall not receive directly or indirectly any commission or remuneration for recommending a particular product, supplier, service provider, or contractor to a client for work on a building project without informing the client in writing. SECAP has received and investigated a case where an RP referred a client to a particular service provider. The service provider thereafter rewarded the RP with an all expenses paid trip to overseas. The client was not aware of this arrangement between the RP and the service provider. So this sub-rule generally precludes RPs from receiving payment for making any recommendations or referrals to their clients unless the client is informed of such in writing. If a registered person contravenes this rule, he may be sanctioned to a fine of 5,000 and 10,000 rands. We proceed to Rule 1.9, which provides that an RP shall declare to any potential client any business interests, including any interest in the business of trading in land or business of property developers, property auctioneers, estate agents, building contractors, subcontractors, suppliers in or to the building industry, or in a design and build practice, the existence of which interest, if not declared, could raise or may be likely to raise doubts about their integrity and impartiality as independent professionals. So Rule 1.9 is almost similar to Rule 1.8 that has been discussed above. So this rule or this sub-rule seeks to ensure that registered persons do not put themselves in situations where they will have their interests conflicting with those of their clients. A contravention of this rule will attract a sanction of a fine of between 15,000 and 20,000 rands. Rule 1.10 provides that RPs shall remain bound by these rules, even after the occurrence of non-payment of the annual registration fees and after suspension of registration in terms of Section 20, subsection 1A3 of the Act, due to failure to pay prescribed annual fees. SECAP has not investigated contravention of this subgroup. An example, however, of compliance with this subgroup is that RPs must always hold themselves to the standards set out by the Code of Conduct, whether their annual fees are up to date or not. The suspension of RPs registrations due to failure of paying their annual fees does not mean that they should then cease to observe the Code of Conduct. A contravention of this subgroup will attract a sanction of a fine between 15,000 rands and 20,000 rands. We move on to Rule 1.11, which provides that RPs shall not practice architecture during the period in which their registration has been suspended in terms of Section 20, subsection 1(3) of the Act, due to failure to prescribe their annual registration fees. An example of complying with this subgroup would be for RPs to advise their clients to appoint another RP to take over the work when such RP has failed to pay his prescribed fee or when their registration is suspended. So continuing to practice architecture in contravention of the subgroup is similar to contravening Section 18, subsection 2 of the Act. And an RP who is contravening this section may be prosecuted by the state. And a contravention of this subgroup in particular may attract a sanction of between 5,000 rands and 10,000 rands. Rule 1.12 provides that RPs shall not practice architecture after their registration has been suspended in terms of Section 32, subsection 3A, Roman figure 3 of the Act, due to being found guilty of improper conduct by a disciplinary tribunal. So an example of complying with this subgroup is identical to the one which has been provided under subrule 1.11. A contravention of this subrule is similar to a contravention of Section 18 as well of the Act, and it may be prosecuted by the state. And contravening this subrule may also attract a sanction of a fine of between 15,000 rands and 20,000 rands. Rule 1.13 provides that RPs shall not practice architecture after their registration has been cancelled in terms of Section 32, subsection 3(1), Roman figure 4 of the Act, due to being found guilty of improper conduct. Similarly, an example here will be as per the 2 points that have been discussed above. And a contravention of this subrule is also similar to a contravention of Section 18, subsection 2 of the Act, and as well it may be prosecuted by the state. A contravention of this subrule will also attract a fine of 15,000 rands to 20,000 rands. Rule 1.14 provides that the RPs shall not practice architecture after their registration has been cancelled in terms of Section 20, subsection 1 of the Act. Similarly, in this subrule, the examples will be as per the 3 points that have been discussed above. And a contravention of this subrule will attract a sanction of between 15,000 rands and 20,000 rands. We proceed now to discuss Rule 1.15, which provides that RPs shall treat clients and fellow registered persons with due dignity, respect, and courtesy. So the SECAP has previously investigated a case where an RP used foul and offensive language towards his client. The SECAP discourages such conduct, and as such, if any registered person is found to be contravening this subrule, a fine of between 15,000 rands and 20,000 rands may be meted out by the tribunal. Rule 1.16 provides that RPs shall, in giving advice, exercise impartiality and independent professional judgment. This sub-rule basically requires RPs not to be biased when they are giving professional advice. They must be professional at all times. A contravention of this sub-rule may attract a sanction of a fine of between 5,000 and 10,000 rands. The last sub-rule under Rule 1 is Rule 1.17, which provides that registered persons shall not engage in any act of dishonesty, corruption, or bribery. So in a sense, this rule means that RPs must be careful not to conduct themselves in a way that may attract some criminal sanctions against them. They must be careful not to offer any bribe to suck up officials or members of the public to sort of make their problems go away. If the SECAP receives any complaint that relates to a contravention of the sub-rule, the SECAP tribunal may mete out a sanction of a fine of between 5,000 and 10,000 rands. So, fellow RPs, when one looks at the entire Rule 1, it is important to note that this rule uses the word shall. This means that it is mandatory for RPs to comply with the code of conduct. It doesn't give RPs the option to exercise any discretion whether or not to comply and abide by this rule. They have to comply, they must be compliant at all times. And when one looks at the term integrity, one must always understand that this term means and requires RPs to act in a way that is capable of distinguishing between right and wrong, and to always uphold high moral principles. That will be all from my side, fellow colleagues. Thank you very much.
Thank you very much, Mr. Matebula. That was a mouthful. I hope RPs have a pen and a paper in front of them. They are making notes as we go, because I believe that this will be of assistance as they practice in their practices, or it will be very important also in their day-to-day running of their projects. And also, I want RPs to take into consideration that after this presentation, we'll also be running a survey where you will be required to answer questions. This will assist SACAP in understanding how much do you know the code of conduct, so that we can better our presentation, and then also we can custom made these presentations. So please, you will receive an email. Please respond to those questions. And also in terms of the question and answer, just as we go, just write your questions, and then you will get a chance to ask your questions when the times allows. So just have a pen and a paper. So now we will be moving on to our second speaker of the day, Mr. Ntamanizeni Makakabule, who is he's an investigator at the legal department. So he understands exactly what is required here, and then he will be taking you through Rule 4.1. Please pay attention, have a pen and a paper, because he will also be referring on remedial actions that you may do if you don't want to be found guilty of contravention of Rule 4. So please just have a pen and a paper as well. So I will take it over to Ntamanizeni Makakabule. Thank you.
Thank you, Program Director. Good morning, colleagues, fellow registered persons. So, like my colleague has indicated, I am Ntamanizeni Makakabule. I am with SECAP. And if you can see my graph on my presentation, I'll just dive into it. As you can see, I have a graph there which indicates the type of charges, wherein my colleague has already presented on Rule 1.1, wherein it talks about it talks about the integrity. So I will be focused on Rule 4.1. As you can see there on Rule 4.1, that is, I can say with confidence that Rule 4.1 is one of the most contravened rule. This actually, it's not necessarily Rule 1.1. If Rule 4.1 is the entire Rule 4, wherein we receive a number of complaints from this rule. So I will be focused on that. And then my colleague will also focus on other rules as indicated there. So one thing, colleagues, also to mention that this graph is based on a number of complaints that we receive. Is not actually 3 or as it stated there 13, but this shows that these are the most contravened charges. So the entire code of conduct should be complied with, but then this is what we have seen, that on a day to day, these are the contravened, these are the charges that these are the code, these are the rules that are mostly contravened. So I'll just dive into it. And so on my presentation, in terms of Rule 4, you see that I've got my table of contents, wherein on the table of contents, we have written agreement, terms of appointment, client signing off, issuing of drawings. So I'll be going down to responsibility. I'll be taking you through all these sub-rules to make sure that we do not find ourselves in contravention of those sub-rules, and that we comply with the rules. So in terms of Rule 4.1, it says here that registered persons shall ensure that before they undertake any professional work, they have entered into a written agreement with their clients, which must inter alia include, this will be going down to 4.1. We find there on A is that we must have a proof of professional registration, the scope of architectural work. This is one, okay, so this is what you must have in your terms of appointment with your client. So what you must have, you must have your proof of professional registration on the agreement. You must have the scope of architectural work on the agreement. You must have the scope of service to be provided. You must also have the allocation and limitation of responsibilities, the fees payable for the architectural work or services, the method of fees calculation, if appropriate, and the stages at which the fees will be payable. We have G, where it has a provision of dispute resolution. H, termination of the agreement. I, we have details of provision and indemnity insurance, insurance including name of the insurer, the name of the insured. Also the amount covered, the policy number, and the validity period. So because we have noticed the contraventions of this rule from a number of complaints that we received, SACAP has, in an effort to try and make sure that RPs, these are the registered persons, comply with these rules. They have, we have came up with an agreement which complies with the code, which we have on our website, wherein if you look.
Okay, boss. Yes, leader, sorry.
I have an option to reset.
Sorry, leader. Sorry for that. So yes, so SACAP has came up with a contract. We have 2 contracts that are there on our website. If you go to our website and go to the option where it says for the public, you click there, and then you'll be able to download the contracts which comply with this rule. So we also have those contracts. We've put two contracts there, a high complexity one and a low complexity one, wherein you as an RP can decide to say, okay, fine, this is you can decide as per the project that you have, which type of contract you'd use on that, and then you can download it and sign with your client. This is where we have noticed that if maybe RPs who cannot afford maybe to draft it through their legal professionals, or if they cannot do it themselves. So that's what we have done to try and assist our RPs to comply with this rule. So common contravention of this rule is that registered persons firstly do not conclude a formal contract between them and their client. So we found that most times there are complaints wherein there was no formal agreement at all, and then the only agreement which is there is just a verbal agreement. So which then fails to comply with this rule in its entirety. And in terms of verbal agreement, SACAP, in an effort when we have indicated that there's a contract there that you can use, we're trying to avoid a situation where it's a he said, she said situation, wherein if things are put down in writing, when we receive the complaint, we can see, okay, fine, Tom was appointed to do this. Did Tom do this? No. And then it can be easier for us and for the members of the public and the registered persons, because sometimes you might find that no, you have been appointed, but then the appointment was not in writing. The client saying, no, I appointed you to do this, and then you said no, but you said I must do this, and then that's what we are trying to avoid. And it assists you as a registered person to say, no, fine, this is the contract, you signed on this, we agreed on this, and then it exempts you. So if there's a complaint that you failed to perform as per appointment, you bring the contract and say, no, this is what I and the client has agreed upon, and then you produce that document where it says that you performed this, and then you produce such evidence that you've performed that. A case can be dismissed on that basis. So that's what we are trying to do as per SECAP, trying to make sure. So it should be also be noted that failure to put your terms of appointment in writing as requested by the code is not only professional misconduct, but also works against you as a professional should you need to claim for your money for work performed or other legal litigation that might arise on the project. You would have a leg to stand on. So obviously that was what I was appointing. I was indicating that you would have a standard. You would have a leg to stand on. You'd indicate that no, this is what we agreed upon, and then it's there on paper signed by both parties. So secondly, registered persons would have their terms of appointment in writing. However, on the terms of appointment, registered person would fail to include all the clauses that are required to be included in the contract. For example, this would be failure to provide for the termination clause, the dispute resolution clause, and lastly, failure to provide for professional indemnity clause where you have failed to put your name of insurer, amount, and all that is required by the code. So SACAP, in an effort, has to try and assist registered person who cannot afford legal fees to draft the said contract, amongst other constraints, has developed two contracts for the registered persons that they can make use of. SACAP has, in an effort to try and assist registered persons who cannot afford legal fees. Okay, so this is what I was indicating, and I was just talking from my head. So this is where I was indicating that we have established a contract where you can download and get assistance on. So the rule sub-rule 4.2, it says that registered person shall not change the terms of appointment, including the scope of work, without written instruction or approval of from the client. So although the rule is self-explanatory, it is one of the important tasks, if not the most, on the agreement. The registered person is an agent for the client, and that his client that has to prepare for the plans for his client. So here, so what we're saying is that should you enter into a contract with your client, when you proceed with your professional work, you should not change the scope of the work, and or change, yes, you should not change the scope of your work without the written instruction from your client or approval of the client. So it means that client must be informed. You must inform your client of any change of any scope of work, and the client must consent, because we have instances where clients came to SECAP to say, no, I appointed Tom to do this and as per this budget, but however, Tom later on came up with this fee that we did not agree upon, and then Tom, when we request Tom to respond to that, Tom will be indicating that no, look, I did this as per the rules and regulations, or as per the national building regulations, or as per the council's requirements. I could not do this, and hence I did this. But then that should be communicated with the client to say, no, look, this is where I am. The council cannot do this, cannot approve these plans because there is a need for a site development plan to be prepared. So this is where we are, and then your client will then have to consent to that, and also will have to know that if there is any extra fee that needs to be charged, he will be responsible for that. But sometimes RPs just go on, and then there is a bill, and then the client will be coming to us and say, no, look, this is not what we agreed upon. This is what we agreed upon. It was 10,000 rand, but then now he's bringing me a fee of 20,000. We didn't agree on that. Yeah, so we're trying to make this will tries to make sure that registered person shall not change the terms of appointment, including the scope of work, without written instruction or approval from their clients. So rule 4.3. This rule talks about registered person shall ensure that the completion of each milestone the client signs off the scope of work involves more than where the scope of work involves more than one stage. So there is a situation wherein you'd find that you would be preparing plans, maybe appointed from stage 1 until stage 4 until stage 6, and then from each milestone, the code requires that each milestone, the client must sign off where the scope of work involves more than one stages. So this rule assists the registered person to keep track of their milestone on the project, and also assist where the client alleges that such work has not been done, and such proof can be produced to confirm such performance of such milestone. Signing off of plans by clients before the plans are submitted is also important, as it also proves that the client has seen the plans and has approved them and has approved them to be submitted. This provides the clients the courage and transparency with the work during the stages. So this is obviously important wherein the registered person would be protected, wherein he or she is saying that no, this you have not done, or maybe at some point that this is not what I said he must do. So if you are going to be performing your work, and after that at any stage you indicate to your client to say, no, this is what I've done, and then the client would look at it, and after looking at it, after assessing it, after maybe having a brief discussion, would say, okay, fine, we can proceed. So it then assists wherein the client cannot come back after maybe plans being approved, say, no, this door, I didn't want this door here. And then you can produce that proof to say, but then you, after we performing this or such stages, you agreed and you approved this, and then we continued on that basis. So we also have rule 4.4, where the rule talks about registered person shall only issue drawings, specification, or document in respect of work performed or administered by them or by a person in their employ, which bears their name and or registration number or the name of the architectural practice. So this rule has been widely contravened unethically by registered persons, whereby we have had complaints of registered persons signing off unregistered persons' work and unqualified registered person who work for submission. So this would mean that you'd find that registered persons are signing off plans which they did not prepare. Wherein maybe there is a situation where one would just sit and then unregistered person will come and then he just signs off. He doesn't prepare those plans. He just signs off, and then he's assisting these unregistered persons to perform work without being registered. So the code is talking about that you shall only issue drawings specified or documents in respect of work that has been performed or administered by you or by a person in your employ which bears your name and or registration number of name or name of that architectural practice. So all these other, or maybe when you find that there is we have situations where unqualified in terms of the identification of work, this person is not qualified to prepare this work, but then he comes to you and then he wants your signature, wherein you sign for them so that they can submit, but you didn't prepare that work. So the code, the rule discourages that act. So we go on to rule 4.5, wherein a registered person shall sign or otherwise identify as having been issued by them any building plan or document which their architectural practice is the bona fide author, or where such building plan or document has been prepared under their direct supervision. So, sorry. So in terms of this code, in terms of this rule, we have often seen contravention of this rule where a registered person sign off copied work that belongs to other professionals making their work and submitting such work to local municipality for approval. This conduct is not only contravention of the code of conduct, but is also contravention of Copyright Act, and registered person can find themselves being sued by original authors of those documents. So it is not the first time we've received numerous complaints wherein RPs are indicating that no, these plans are mine, and then through investigations we have been able to find that these plans were not prepared by the second architect in question in the investigation, wherein it is clear, because the author would present to us the plans that he prepared, and then we would request that the second architect present the same plans to us, and then through investigation we then established that no, this indeed was a copy from this guy, and then that obviously even the initial author can pursue that with the courts, and then you could be found you can be found in hot water. So moving on to 4.6. The rule talks about registered persons shall attend to all corrections requested by the local authority on the drawings prepared by them within a reasonable time. Plans are submitted to the local authority on a daily basis, and having them refused by the local authority is not a misconduct. However, failure to attend to such comment within a reasonable time is. So on a regular basis, we get complaints from members of the public complaining about their registered, their architects or their registered professional that, no, we have received comments, and then this person has not attended to these comments. And then you'd find that when we communicate with the municipality would indicate that, no, these comments were sent to the registered person. However, since the last 6 months, we have not received any update from this registered person. So that talks to within reasonable time. And you'd find that even the comments that were raised, by the local municipality would be such that no, submit, maybe you find that it's just a mere compliance certificate. It's just a mere show the registration number on your plans. Simple things that could be done within a day, but then the person has taken more than 6 months to submit that. So this is where we have found registered persons failing to comply with this rule. We also have rule 4.7, where it says the registered person shall issue certificates that are based on the correct facts on site. This rule relates to issuing compliance certificates, the recommendations of occupational certificate by signing off since 10400, and any other issuing of certificates that are issued under the performance of architectural work. So we have on a number of instances received complaints that registered persons have issued certificates unethically, where one has signed off from 4 to be compliant, while in fact this is not the case on site. One example was that of a plan directing that a solar geyser must be installed on the property for energy efficiency, and then the homeowner inspected and found out that this was not installed, and then the registered person had indicated that all has been prepared and installed as per the approved plans. So these are, it's similar to the role that was discussed with my colleague there in integrity. So this talks about your integrity, like what is on site. You can refuse if you see that this is not what is on the plan, and then it's not, you can refuse where you find what is not on the plan is not what is on the ground. You can refuse because at the end of the day, your signature will be the one that we will receive to have been the one who has signed off to say this has been complied with. So we will then, during our investigation, obviously, that is a misconduct where you have indicated such, where it does not correlate with what is on the ground. So in terms of rule 4.8, Rule 4.8 says that registered persons shall take adequate and appropriate professional indemnity insurance to cover all architectural work undertaken. The primary importance of professional indemnity insurance for working individuals is that professional indemnity insurance protects professionals against liabilities arising from their professional practices. We have had professionals being sued in their personal capacity and having to pay legal costs from their own pockets after failing to adequately have adequate indemnity cover. Some clients do not appoint professionals without professional indemnity, as they know that they are not protected should a negligence arise from the professional work. This is not an option. It is a requirement to protect both the clients and the professionals. So, like my colleague indicated, that this is a mandate. This is mandated by the code of conduct indicates that you must. So it's not an option wherein one would feel that no, I shouldn't, or I don't have, and I'm continuing with it. So when we conduct our investigation, also in terms of Rule 4.9, the Rule 4.9 says that registered persons shall, when requested by SACA, provide evidence of professional indemnity insurance within a reasonable time. So after a complaint has been lodged against a registered person is required to respond to the complaint under oath, submitting his response accompanied by plans if there is any terms of appointment and details of his or her professional indemnity insurance. Failure to provide evidence of professional indemnity insurance will render improper conduct by the registered person. So you will be informed to submit that professional indemnity insurance to us when we have when there is a complaint that has been laid against yourselves. So it is a requirement. So in terms of Rule 4.10, Rule 4.10 talks about registered persons shall within 30 days of change of their professional details, such as email address, physical and postal address, telephone numbers of their practice, inform counsel in writing thereof and ensure that such details are kept up to date. So a registered person must inform the counsel of any changes of their contact details within prescribed time. This is to make sure that all communications between the council and the registered persons are done without hindrance and that the rightful person received the communication intended for them. So they also in terms of complying with the rules and the laws that govern our institution, also the POPI Act, we must comply with the POPI Act. So should we have a situation wherein we need to send you our documents, we need to send you invoices and all that, we must make sure that we have your correct details so that the information that must be sent to you gets to you, not that maybe you change work and then next you leave your work email. You provided us with your work email and then you change. Next month you're working for Tom and then you're using Tom's email, work email. And then when we send you our correspondence, we're sending them to the previous employer, and then the previous employer receives information that is not intended for them. And then that will mean that we will have failed in our attempts to get our information to you. So you should, within 30 days, of change of personal details such email address, physical address, postal address, telephone numbers, and practice inform us so that we are aware of the change, and then we send you what you need to receive. So in terms of Rule 4.11, Rule 4.11 says that registered persons shall keep all plans, records, certificates, and/or drawings commencing from the start of work and up to a period of 5 years from the date of final completion. So this rule is intended to regulate the period in which the registered persons are to keep their work documents in general for a period of 5 years. After such project has been completed, registered persons who have archiving spaces are not deterred to keep records longer than they can. However, the minimum period required for them to have those records should they be required is 5 years from the date of final completion. So keeping of record is important since some registered persons might need such records for their portfolios in the upgrading of application process. So it is important to keep, if you have space, you can keep them longer. But then if you do not, just make sure that you keep them for 5 years. And also, like as I indicated there, like maybe you'd need an upgrade or you need a portfolio to send. Obviously, you'll need your work. You shouldn't have to worry about where it is. We know where you've kept it, and when it is required, you can be able to retrieve it and present it. So in Rule 4.12, Rule 4.12 says that registered persons shall not disclose confidential information obtained from clients except with written permission and in compliance with the Protection of Personal Information Act. So as per the previous rule, it's important to comply with this rule and regulations that governs your work environment. It has the potential to affecting your business in a negative way to a point of collapse. So registered professionals on a daily receive personal information of clients that is confidential. Registered professionals are advised to use the confidential information received from clients on what that information is intended to, and nothing else unless prior written consent from the client. So obviously, when you are doing your consultation, you receive personal details from your clients. That information must only be used for what it's intended for, and not any other thing that the client has not given consent to. So that, yeah, in terms of not only that it complies with the Code of Conduct, but also the POPI Act. So you must comply with the POPI Act yourself also. So in terms of Rule 4.13, the rule talks about registered persons shall carry out professional work within agreed time or within reasonable time. A registered person, when entering agreements or looking to be appointed for work, tend to provide clients with timelines that either they cannot meet or fail to meet the agreed timeline. So sometimes maybe, because this is what we see when we receive complaints, an RP would say, no, sorry, I'm going to have this prepared or approved in 2 weeks. We've seen such time that RPs have agreed with the clients. So in 2 weeks, you can see that no, this cannot happen. So RPs, since this is your profession, you know the times, you know how long the council is going to take, you know how long you're going to take to prepare the plans. So ethically, just give the client a fair time period, wherein if you have indicated a time period that you cannot meet yourself, then that is in contravention of the rule, because the reasonable time, your client does not know what time is reasonable. You know what time is reasonable, so you should indicate that no, look, the client, the council is going to take 3 weeks to circulate the plans. If there's any corrections, I will have to prepare the plans again and resubmit them to the council, and you give a fair time period. However, complaints are reported with duration provided by the registered persons, and which that timeline having lapsed before the completion of the period. The registered persons, registered professionals are required to keep to the agreed time frame agreed between the parties, as it is the registered person responsibility to make sure that he or she provides the client with a reasonable time frame that he or she can achieve. Other complaints reported where registered persons have taken an unreasonable time to perform as per appointment, which is in contravention with the rule. So we have situations where plans have taken more than 3 years, and then you can see that this is not reasonable time. So registered persons are reminded to make sure, because some will be coming with complaints saying, no, I was busy with other. If you are busy with other things, maybe rather not take the client, because if you're not going to be able to fulfill the time period that you've agreed upon, it's going to be investigated, and then that will be a misconduct should we find that a reasonable time was not adhered to. So there's agreed time and there's reasonable time. On rule 4.13, we also have rule 4.15. Okay, so this will be a repetition. So this will be rule 4.14. So rule 4.14 indicates that registered persons shall keep their clients informed in writing about the progress on work undertaken on their behalf within reasonable time. And if any issue which may significantly affect its quality or cost, and any other consideration which may substantially affect the project. Similarly to rule 4.3, keeping your clients informed in writing about the progress of the work done as is important. This rule assists the registered person with tracking their own progress and also informing their clients of informed about the progress of their work. The rule extends to informing clients in writing of any issue which may significantly affect its quality or cost, and or any other consideration which may substantially affect the project. Registered persons often fall victim to this rule by noticing significant changes on the project and not informing their clients. The client's budget get exceeded, and clients are left to foot the bill. It is important to inform the clients or any of this, and let the clients be aware of, and take responsible and informed decision on the matter. To avoid she said, he said, it is required that registered persons keep their clients informed in writing so as to prove that this was indicated to the client and this was the client's response. So it is easier wherein there is a nice flow communication or in writing in the project, wherein you should not be found to have done something that you were not supposed to have done. Where there's a flow communication wherein the client was informed, wherein the client consented to this, and wherein you have proceeded based on those instructions, that is how the code intends your flow of communication on the work stages and progress. So in terms of rule, okay, I've just moved from rule 4. Let me just go back to my presentation. Just give me a second. I just lost my presentation when I was looking at what to present next. So the last part of it would be rule 4.15, wherein registered person shall take responsibility for work carried out by their subordinate, including persons registered as candidates. So in terms of this rule relates to principle of practices to always uphold the code of conduct in all respects, and where they see that such is not complied with by their subordinates, bring it to the attention of SECAP to make sure that they are not held liable for misconduct that they are not that they have not committed. For instance, work performed by a registered candidate under mentorship of their principal, such principal shall take responsibility of such work performed. He or she shall make sure that the plans are properly prepared and submitted. If there is any correction, the correction are attended to. So, colleagues, this concludes rule 4, which we have seen as indicated on the graph, where I've showed that we have a number of complaints with regards to rule 4, wherein it is administrative functions that needs to be done by that needs to be complied by the RPs. To stress the point of contract, let's use the contracts. If we cannot prepare the contracts ourselves, let's use the contracts that SECAP has listed as put down there on the website. Like I've indicated, that is for the public, and then you can choose which one relates to your project. And then from there on, keeping your clients informed, making sure that should there be any change of the scope of work, you communicate with your client, you inform them in writing, the client consents to you going on forward with the project, so that when there is a complaint, you have covered all you've made sure that there's nothing on your side that is going to or probably be said to have been a misconduct on your side. So let's comply with the rule. And this is, like I've indicated, that this is not the only rule that needs to be complied with. There are other rules, but these are significant because we have found that these are the most contravened rules that are being contravened on a regular by registered persons. And yes, thank you. And we'll be waiting for the questions later. Thank you.
Thank you, Mr. Makakavule. Just to stress on rule 4.1, seeing that is the most contravened rule in the code of conduct, is that colleagues, we need to formalize our practice. Having a contract, it's a way of showing that there is a profession, that you're providing a professional service. So by having a contract, it's not a punishment to you as an RP, but it's a way of protection. Legally, you are protecting yourself. Legally, you are making sure that everything is in writing. As Mr. Makakavule has said, that you don't want to be in a situation of he said, she said. So you always put your services, your contract should always be in writing, because verbal agreements are not acceptable. So because it can be he said, I did not know those type of things. So just formalize your practices, what you need to do, use the agreement on our website. And then moving along, thank you so much, Makakavule. And moving along to our next speaker is Ms. Bessie Shope. She's also one of the investigators. She will be taking us through Rule 5. So she will explain what is Rule 5. So just have your pen and paper at hand so that you can take note. And then if you have any questions, just reserve them for our Q&A that is coming. So I will take it over to Ms. Kroppe. Thank you so much.
Thank you, Program Director. Thank you very much. And thank you everyone for the opportunity for us to address you on the common contraventions of the Code of Professional Conduct. As already mentioned, I will be going through Rule 5 of the Code of Professional Conduct, which deals with the establishment of an architectural practice. I just want to first see, okay, there we go. All right, so this is my table of content. My table of content basically embodies what I will be going through with all the professionals today. And as already explained, this is the graph that deals with the type of charges that we are seeing. I'm mainly dealing with the charges that in the yellow, or it's a mustard color, the lime green, as well as the dark green color. Thank you. All right, so now I'm at the commencement of my presentation. The Rule 5.1 of the Code of Professional Conduct provides that any registered principal who practices architecture in any form shall, within 30 days of the establishment of an architectural practice, register it with council, giving full details of the practice name, address from which the practice is conducted, the type of practice, supported with corresponding registration details, and the names of partners, shareholders, directors, and employees undertaking architectural work in the practice. Okay, just forgive me, my screen movement is a bit slow. Okay. It is in the interest of SACAP to know who is practicing architectural work and where it is being practiced, as a regulatory body's mandate to regulate the architectural profession. In a majority of complaints that we receive, registered persons are rendering architectural work for members of the public under practices that are not registered with SACAP, resulting in non-compliance with Rule 5.1. The rule is applicable to persons who render architectural work in any form, as the rule says. Thus, you must list your practice with SACAP, provided that you use the practice to render architectural work and prepare contract documentation. Again, you'll forgive me, my screen sharing is slow. I will just ask IT to help me in that sense. Compliance with Rule 5.1 is peremptory. Upon registration, you will be provided with a practice number. SACAP has a form that registered persons must complete to comply with Rule 5.1 within the specified time. The form and processes of informing SACAP is free. Also, further practice registration with SACAP does not require an annual fee. What I want people to note in this rule is that we have received queries in the past from registered persons who have inquired to say, for example, I am rendering architectural work, but as a sole proprietor, or I have a sole practice, so I'm only rendering architectural work in my name. Is there a need for me to still list my practice or myself with SACAP as rendering architectural work to comply with Rule 5.1? But as the rule says, it is applicable to persons who render architectural work in any form. Thus, you must list or register that said practice as the sole proprietorship with SACAP. For example, when you are advertising architectural work, at the end of the day, you are using words such as drafting services, building plan services. You are still using architectural plan drawings available from BESI. So in such an instance, you still need to be able to come to SACAP and list your practice with SACAP in any form so that you do comply with the rule. Okay, moving on to the next rule, Rule 5.2 of the Code of Conduct. The rule states as follows. The council shall be informed in writing of any changes in name, type, address, and composition of an architectural practice and its termination within 30 days of the relevant occurrence. This rule seeks to ensure that SACAP as a regulatory body has accurate and updated information of all practices rendering architectural work. We regulate the architectural persons and their practices. It is thus of paramount importance and in the interest of the public for SACAP to have accurate and updated information of practice. Registered persons are encouraged to provide SACAP with their updated practice information, as failure to do so amounts to contravention of the Code of Professional Conduct. And then when we look at Rule 5.3 of the Code of Conduct, it provides that the registered principals of a practice shall display their registration certificates in a prominent place in their physical and or virtual workplace. Displaying your registration certificate in your practice provides the public with a proof of registration. It promotes trust and reliability, which in turn benefits the professional when approached for services by members of the public. In a majority of complaints that we receive, members of the public do not have correct information pertaining to the principles of a practice and their registration details of the appointed person. This leads to wrong identification and the inability of clients to communicate with practice principals regarding concerns over service delivery prior to approaching SACAP to lodge a formal complaint. Registered persons are therefore encouraged to ensure that they display their registration certificates in their workplaces to prevent contravention of the rule. Quite easy rule to comply with here. This refers to both Rule 5.2 and Rule 5.3. Then we move on to Rule 5.4 of the Code of Professional Conduct. Rule 5.4 provides as follows: registered professionals and multidisciplinary practices shall not describe or name their practices as architectural practices unless majority shareholding or voting powers are held by registered architectural professionals. This rule seeks to ensure that only registered architectural professionals hold majority shareholding in architectural practices. An architectural practice conducts the business of architecture, and as such, registered professionals ought to hold majority shares in an architectural practice. In a majority of complaints that we receive, registered professionals do not hold the majority shareholding in architectural practices and multidisciplinary practices. In such cases, persons who are not registered with SACAP are holding the majority of shares over SACAP registered professionals, and said practices are then called architectural practices. This is a clear violation of the Code of Conduct prescripts. Okay. I'm sorry, everyone. I'm just going to request so that I can just present on a different laptop because my movement of the slides is a bit slow and a bit delayed on my laptop. This one is working perfectly. Just again to apologize to everyone for that disturbance. Let's move along. Okay, we are moving on to rule 5.5 of the Code of Conduct, which states that in any multidisciplinary practice, professional firm which practices architecture, a registered principal shall be responsible for the architectural work or for the architectural work, and all provisions under the Code of Conduct shall apply to multidisciplinary practices. So this rule is directed to multidisciplinary practices. In accordance with this rule, rule 5.5, only a registered principal shall be in charge of an architectural department in a multidisciplinary practice, and they shall be responsible for all aspects of architectural work rendered therein for the public. An unregistered person has no business in meeting with clients, rendering architectural work, preparing contract documentation, as said acts are reserved for registered professionals only. We receive in a majority of complaints received relating to multidisciplinary firms, there is no clear distinction between an architectural department and the other department of other professionals involved in said multidisciplinary practice. Unregistered persons are thus involved in the rendering of architectural work. They are involved in the soliciting of clients. They are also involved in taking the client's brief, preparation of contract documentation. We find that registered persons will only be involved in the drawing of the plans and not in all other aspects of the provision of the architectural services for members of the public. This is unacceptable and a violation of the Code of Professional Conduct. In a majority of complaints received, persons that are registered in the category of candidate are in charge of architectural work in multidisciplinary practices. A person registered in the category of candidate cannot engage in any other business other than that of a candidate. Only a registered professional can thus be responsible for architectural work in a multidisciplinary firm. We do see this a lot in our complaints, where you will find registered persons are opening multidisciplinary practices, and then they will get a candidate, or they will then have majority shareholding, which obviously in accordance to the rule, this is unacceptable. We also encourage persons who do see this happening to also bring it forward to SACAP. And obviously during an investigation, when we receive a matter, we will always look into the establishment of said architectural practice. We will have access to see who is holding majority shareholding. We will also be able to see when we do research about the company to see who is handling the architectural work in the company. And also keep in mind that members of the public, when they do approach SACAP to lodge a complaint, they will detail who took the scope, they will detail who they met with, they will detail whether or not they were even aware of a registered person being involved in said multidisciplinary practice. And we are moving on. In a majority, let me see. Okay, I did already go through this. Rule 5.6, we're moving on to Rule 5.6 of the Code of Professional Conduct. Rule 5.6 provides as follows: a registered person shall not accept with the permission of counsel and under such conditions as counsel may prescribe, enter into any professional relationship or association for purposes of performing architectural work with a person who is not registered or a registered professional of a closely allied profession. Permission will not be granted if the person concerned is disqualified from registration under any provisions of the Act or from membership of any closely allied profession, or is qualified to register under any category in the Act, however, refuses to do so. On this rule, the Code of Conduct seeks to prevent the performance of architectural work by persons who are not registered with SACAP. And in the same vein, upon the registered person informing SACAP of his association with an unregistered person, it aims or it seeks to assist such unregistered person to register in the category that he or she may be eligible to register under. Instances where registered persons are to have contravened this rule is when a registered person enters into a professional relationship or associates himself or herself with someone who is not registered with SACAP for the performance of architectural work. For example, a registered person working in his office with a person who is not registered, where that person, this is the unregistered person, consults with members of the public, takes measurements, and also prepares plans for members of the public. Some registered persons would even have unregistered persons use their registration details to submit plans to the municipality. The unregistered person would have a company that would be practicing as a registered person, preparing plans, issuing out invoices, and receipts under his company letterhead to his bank account whilst not registered. We take up using the registered person's registration number for a fee or for some type of other arrangement. Registered persons are urged to comply with this rule. It is also, it assists in making sure that only registered persons perform architectural work and thereby making work available for registered persons. We also encourage persons who are registered, who do notice this happening out there in the public, to bring it forward to SACAP. In a recent case that we have investigated, we found that sometimes registered persons should also be aware where they are approached by a person to say they are approached by an unregistered person who's doing work, and they say, for example, I have a client and we have a plan. For example, there was a reason why the unregistered person could not finalize the plan, either due to their registration not being acceptable, obviously, at the municipality. And then you find that that registered person will say, not a problem, I will accept and I will continue. But now, because the client had already given the brief to the unregistered person, had already discussed fees with the unregistered person, then you find that the client pays the unregistered person, who then pays the registered person. So in such a case, we still find that there's a link, whereas, for example, you're not necessarily working with that person on everyday basis because you as a professional have failed to do your own meeting with the client, your own contract documentation. You have failed to ensure that all fees relating to that architectural appointment are given directly to you as the registered person. And in such a case, you find yourself that now you are seen as associating yourself with an unregistered person. And obviously, in any circumstance, wherever you know that an unregistered person is approaching you to form some form of an association, this is not allowed. And obviously, you must first seek permission from SACAP before you enter into any association with an unregistered person. So registered persons should be careful, and obviously to protect the dignity of the profession, they should bring forward such relations that they are aware of out there to SACAP. Moving to Rule 5.7 of the Code of Conduct. Rule 5.7 provides as follows. Every office established for the purpose of conducting an architectural practice shall be under the continuous, direct, and personal supervision of a registered professional who shall continually review and oversee the work of the practice. The registered professional shall be in attendance for a period of at least 8 hours per week. The registered professional shall prominently display their office hours and contact details on electronic platforms or place of operation. In this rules, we seek to ensure that registered professionals are actively engaged in architectural practices. It seeks to prevent unregistered persons and candidates from running architectural practices and rendering architectural work in the absence of registered professionals. The rule requires registered professionals to be present in the practice and to be responsible for the reviewing and the overseeing of all work conducted in the practice. We then move to Rule 5.8 of the Code of Conduct, which provides as follows. The type of practice shall be determined by the registration category of a registered principal actively engaged in the practice. This rule encourages honest promotion of architectural services to the public. It aims to prevent registered persons from misleading the public into believing that they are in a higher category of registration through their practices to secure work opportunities. In accordance with Rule 5.8, the type of practice shall be determined by the category of registration of the principal. Registered persons tend to name and describe their practices to be in a higher category of registration than that of the principal. In such cases, they seek to pursue work that is reserved for persons registered in a higher category of registration. Registered persons are expected to render architectural work in an honest manner by conducting work reserved for their category of registration. Rule 5.9 of the Code of Conduct provides as follows. The practice shall not use a type which portrays itself by name to be in a higher category than that of the registered principals who own the practice. This rule is similar to Rule 5.8 of the Code of Conduct, which we just dealt with, which deals with the type. This one also deals with the fact that when you are naming an architectural practice in an effort to mislead the public into believing that you are in a higher category of registration. The rule encourages honest promotion of architectural services to the public. It seeks to prevent registered persons from misleading the public into believing that they are in a higher category of registration through the names of their architectural practice to secure work opportunities. We receive a lot of complaints where registered persons tend to refer to their architectural practices as practices of professional architects, whilst they are registered in the category of professional architectural draftsperson, or professional architectural technologist, professional senior architectural technologist. In such a case, you find that there are no principals registered in the category of professional architect in said practices. So this applies to, you could be a draftsperson, referring to your practice as that of a technologist. You could be, as mentioned, we see a lot of draftsperson. For example, if I was registered in the category of draftsperson, I would then say basic architects to create the impression of in the public that I have a practice, and in this practice, they are professional architects. But obviously, as mentioned previously, when we receive a complaint of improper conduct, we will look into the practice establishment. And remember, this is evidence that we find in your quotation, your contract documentation, your invoices, your communication with your clients, in your email letterheads. We will see the practice name. We will be able to obviously see your category of registration. We will be able to also see how you are advertising yourself out there on social media. How is your company being portrayed to the public? And this is easy evidence to find against you. So it is much better for you to stick to your category of registration and obviously advertise your practice as per your category of registration. Registered persons should refrain from portraying their architectural practices to be in a higher category than that of the principal of said practice. Such conduct amounts to violation of the Code of Conduct. We now move to Rule 5.10 of the Code of Professional Conduct, which provides as follows. Sorry for that. A person registered in the category of candidate shall not establish an architectural practice, act as a principal, or a shareholder in an architectural practice. Numerous complaints received by SACEP relate to persons registered in the category of candidates rendering architectural work for members of the public independently, without supervision, and under their own architectural practices. In such cases, persons registered in the category of candidate mispresent themselves to unknowing members of the public and use their principal's details to submit building plans for approval. The above acts are unacceptable and they are detrimental to the profession. Persons who are registered in the category of candidate lack the required level of skill and competency to undertake architectural work independently. As a result, members of the public are often left stranded with incomplete works and inadequate building plans. Rule 5.10 ensures that a person registered in a category of candidates cannot establish an architectural practice. A candidate cannot have any pecuniary interest in a practice other than in respect of bona fide remuneration for services as a candidate. This rule seeks to ensure that a person registered in the category of candidate cannot engage in any other business other than the business of being a candidate. What I also want to be pointed out in this rule by registered persons is that you must obviously bring forth, when you do see architectural companies that are being run by candidates, to a SACEP. However, I also want to make reference to a rule in the Code of Conduct, which is Rule 2.5. Rule 2.5 states as follows, and this rule is applicable to registered persons who are playing the role of mentor to persons registered in the category of candidate. It states that registered persons shall ensure that registered candidates do not have any financial interest in an architectural practice or a multidisciplinary practice that performs architectural work other than in respect of bona fide remuneration for their services. In a majority of complaints that we receive, you will find a situation where the mentor might say yes, because we will, whenever we are investigating a person who is registered in the category of candidates, we will obviously seek communication with the mentor. We want to confirm whether or not there was any mentorship for that particular client's project, or for that project, or in general of that candidate, when we see that the candidate is practicing under their own architectural practice. And even to you as candidates, obviously it's easy for us to determine the registration or the formulation of a practice. We will do an investigation onto that, and we will see that you are the sole director of said practice. Now, when it comes to the mentors, because this rule also puts responsibility on you as a mentor to ensure that your candidate is not having a financial interest in a practice other than for remuneration of services that they render for you. We have a lot of situations where the client doesn't even know the mentor, had no idea that there's a mentor involved, where from the onset, the candidate was mispresenting himself as the sole person rendering architectural work, where they only find out that there's a mentor involved when they look at the title block of the building plans and they see the registration number of a different person, or they see the name of a different person, and that's where now they will say, oh, okay, it seems as though this person was under a mentor. So it's very important, if you are a candidate, to know that all work that you are doing must be done under your mentor's practice, including the soliciting of clients, contract documentation. Everything that you do must be under the direction of your mentor, meaning that from the moment you go to visit the client, you make it clear to the client that you are doing all of this under who and whose instruction and or direction, to avoid contravention of Rule 5.10, or to avoid to be found or seen as though you are practicing architectural work independently. Yeah, I may have moved a bit towards to there, sorry for that. Okay, we now look at Rule 5.11 of the Code of Conduct. The Rule 5.11 of the Code of Conduct provides that letterheads of an architectural practice shall display the following. So it relates to your letterhead as a professional. This is also a commonly contravened rule, because obviously there is documentary evidence that we received during investigations that shows the letterheads that you as professionals are using when you are rendering services to members of the public. The rule states as follows: the letterhead of a practice shall display the following, shall display the name of the architectural practice, the practice number, and the type of practice. It shall also display the names of the principals and their registration numbers, the category of registration of the principals using the prescribed titles: professional architectural draftsperson, professional architectural technologist, professional senior architectural technologist, and or professional architect. It also requires that the letterhead must display the professional designation and the qualification of all principals who are not registered with the council, the physical and postal address, telephone, email, companies, and intellectual property commission registration, the value-added tax registration numbers if applicable. It also requires that registered persons shall use, let me end there. In relation to Rule 5.10, as also explained by my colleague previously, it's very important for SECAP to have information, to have this information, and for members of the public to have this information when you are rendering architectural services for them. This is an easy rule to comply with. You just need to be mindful when you are doing your practice letterheads or compiling your practice letterheads as to what it is that the rule requires, and obviously then you include the information that is applicable to you. Again, this information is seen in all your contract documentation. Thus, it is very easy for SECAP to see or find you contravening this rule through communications that you have with your client and the documentation that you have in your practice. And then also Rule 5.11e provides as follows: registered persons shall use their titles and SECAP registration numbers in all architectural reports and other documentation relating to their work in the architectural profession prepared by or for them. And then also Rule 5.11f provides that practices or registered professionals may not display the council's logo on any corporate stationery or letterheads as it is protected in terms of trademark laws. So diving into this rule, it seeks to formalize and professionalize the registered person's documents. The letterhead of an architectural practice is a document presentation of the practice and its professionals. It should be able to describe the practice and also inform the public of the registered persons responsible of the architectural work in the practice. Registered persons tend to omit their registration numbers on their letterheads and the names of the principals, which in turn puts them in breach of the code. Registered professionals are required to comply with this rule at all times on all their documents by amending their non-compliant letterheads to align with the rule moving forward. Registered persons tend to use the suck-up logo on building plans. This is also very common when we do investigations. We will see you using the suck-up logo on architectural reports, practice documentations that are prepared by yourself. This is a contravention of the code of conduct, as the suck-up logo is protected in terms of copyright laws in light of the rule. 5.11, registered persons should refrain from using the SACEP logo. Thank you very much. That is the end of my presentation on Rule 5, the establishment of an architectural practice. Thank you very much for the opportunity to present.
Thank you so much, Ms. Clopper. I hope we have our questions, because now we will be taking questions from all the panelists that have already presented, which is Rule 1, Rule 4, and Rule 5. We will be taking questions on those presentations. Colleagues, may we please limit our questions to the presentations, because that will help. And as the panelists are still here, they will be able to respond to those questions. So I'll be taking questions. You can go on Zoom. There's raise hand there. You can raise your hand there, then we will address your question. Thank you.
Yeah, Chair. I'll then allow Dion, Vivian, Tommy, Marius, and Philip in that order.
Thank you.
Dion, you can ask your question. Vivian, you can ask your question. I see Philip, you can go ahead.
Okay, thank you, sir. I wanted to ask with my question, I should say, if I'm employed by ABC company,
we are struggling to hear you, Philip.
While you are waiting for Philip to work on his system, Dion, you can come ahead. Vivian, Tony. Yes, Philip, you can come on.
Okay. I have been unmuted. All right. Let's see.
Yes, yeah, Philip, you are live. You can go ahead. All right, let me go.
Yeah. Hello.
Yes, Philip, go ahead.
Yes, thank you. I'm sorry for that hiccup. So I was saying I am a registered professional, say I'm employed by company ABC. Is there any provision that disallows me then to register a company of my own on the side while I'm still employed somewhere as a registered salaried employee?
Okay, Ms. Topper will take that question.
Okay, there is no provision in the code of conduct which prevents you from establishing a practice whilst you are employed. Obviously, there are issues with the ethicalness of you using, for example, your employees' time to do architectural work on the side. There are also issues that will come up wherein you are using your employees' resources and obviously taking your employees' clients to do work on the side. So we do have a lot of cases where the moment that your principal in this case, or your employer would then find out, they will then bring it forward to SECAP to say, they've now aware that you are running an architectural practice on the side, and this architectural practice is either in competition with their practice, or obviously you are taking their clients, as mentioned before, the issues that come with the ethical behavior and the integrity, which then becomes an issue.
Yeah.
Thank you. Yes.
That's
So
correct.
you must
No, I
not be
think
registered as a candidate. So you should not be registered as a candidate, because if you're a candidate, you're not allowed to have a practice at all.
that's
Thank you.
correct. Thank you.
Okay. I will take a question from the chat. It's a question also referring to Rule 5 for Ms. Topper. The question is, okay, it's moving. Okay, it's just moved. Okay, the question is, I'm just looking for the question, just coming for me. Okay, it says, hi, it's a question from Mohammed. It says, hi, is it against the code of conduct if a registered architectural draftsperson start a company and employs registered senior technologist, architect, etc., whether it be a full-time or part-time to take on larger project for the company? How does it work?
Okay. So it's not against the code of professional conduct, obviously, for professionals to come together and establish or run an architectural practice. There's no specific rule that is against it. However, the issue here becomes the IDOW. The IDOW, which obviously is in force, seeks to ensure that persons in a specified category of registration render work that is for that specific category. So we find a lot of issues where recently the trend is for people who cannot render work as per the IDOW will then associate themselves with persons who are able to do that work for them in order to be able to submit building plans using those persons' details. So that is not allowed, because the IDOW seeks to ensure that if you're a draftsperson, you are rendering work specifically identified for a person in the category of draftsperson, and so forth with the other registration categories. However, it does not mean that if in an architectural practice, the professional architect will be dealing with work that specifically deals with work limited for a professional architect, then it is a contravention of the IDOW and or the code of conduct.
Thank you. Thank you.
Okay, Chair, let's try again.
Yes.
Muswandile Patrick, Abraham Moloi, and Samuel Jr.
Yes, Abraham Moloi here. Yes,
Yeah.
Abraham.
Then Samuel Jr. Jeche, then Temba Somo. So let's start with Muswandile Patrick, then after Muswandile Patrick, Abraham Moloi, then Samuel Jr. Jeche, then Temba Somo will be the last one.
Thank you.
Okay, Mr. Abraham, you can come in.
Yes, how are you,
Hello?
sir? Yes, do you hear me? Do you hear me?
Yes, yes.
Yes, how are you? Thanks, Tapelo, program manager, program director. Thank you. How are you?
I'm good, thank you, Mr. Amule. How are you?
Yes, fine, thanks. Look, I've got several questions and that relates to the sub rules, but we can spend the whole day on them. My thinking is that SACAP is implementing these rules to protect the public against the professionals. I have one silly question. Who protects the professional from a professional? Why I'm saying that is that you get a situation whereby you get appointed by a company, big company, and they exploit you. And who protects that professional from the professional that has appointed you? It's a silly question, but you know it's based on reality. The other thing, the other question which it's a question against which I wanted to raise it to Mr. Matebula about the integrity. I've noticed that integrity is a very important personality that a professional should practice, but the clients normally push you to a certain extent that you end up losing integrity. Those are the two which I can raise now, because the sub-rules 1A, I've got a lot of questions about the Popia Act, the research team, those two, Tapelo, if they can advise on those two. Thank you.
Thank you, Mr. Matebula. Oh, sorry, there will be Mr. Matebula who will address you, and I will address you on your first question.
Yes.
Yes. You said that it's a silly question. It's not really, because I think there are a lot of registered persons who do not understand, and thank you for raising that question. So I'll refer to Rule 4.1, the one that Mr. Makakabula presented on when he spoke of the contract. That rule, it shows that as SACEP, as much as it's our mandate to protect the public, we are also making an effort to protect the integrity of the profession. I'm saying this because Rule 4.1 requires that your terms of appointment should be in writing. And then it also goes further to explain to you what provisions need to be in that agreement. By you putting those provisions, you are not only protecting the public, you are protecting yourself, because there are legal suits that can be pursued against you. But if you have a clause that addresses dispute resolution in your agreement, it means that therefore you as a registered person, you are being protected by what SACEP has said that you must implement in your agreement. And also when you look at the code of conduct in its entirety, you will see that the SACEP is actually trying to make sure that as much as you are providing a service to the members of the public, you yourself, you're also protected. You look at the Rule 4.14, it says that when you're providing a service to the members of the public, you must put your communication in writing. In so doing so, you are protecting yourself and you are formalizing your practice. Yes, it's our mandate to protect the public, but the code of conduct also protects you. If you can follow the code of conduct as it is, you will be a perfect professional. So by following the code of conduct, you are also protecting yourself and also protecting the integrity of the whole profession. So Mr. Matebula will address you on the second question. Thank you.
Thank you so much, Program Director. Perhaps just to add with regards to the first question, which the professional deems to be a silly question. In fact, it is not a silly question. It's a smart and sensible question. So in your question, I think I heard you say who protects a registered person from another registered person. I think there was a question around
yes, that. Yes, Mr. Matebula.
So the answer, Mr. Mloi, is strictly on Rule 1.15, which states that a registered person shall treat clients and fellow or registered persons with due dignity, respect, and courtesy. So in the event that as a registered person you feel that you are not treated fairly with due dignity or respect or courtesy, or you feel that you are being exploited by a fellow registered person, I think you have recourse to lay a complaint with us in terms of that rule. That is a rule 1.15. Do you understand? Now, moving on to your second, I think it is more of a comment from you regarding clients pushing you as a registered person to the extent that you end up losing integrity. My good sir, my comment to your comment is that whilst you may be pushed by members of the public to an extent that you lose integrity, you must understand that at the end of the day, the one person in this situation or in this scenario who is expected to uphold the code of conduct is you as a registered person. Surely you will have instances where you will be confronted with certain situations, you will be agitated and all of those things. But remember, the code of conduct aims to ensure that you as the registered person, you are always acting in a professional way, you are always acting within integrity, you are always ethical. So whether or not you are being pushed by a member of the public becomes neither here nor there. The duty is squarely on you. It is squarely on you to ensure that you do not offend this code of conduct. Perhaps if you were to be pushed to the extent of losing your integrity, and then you are reported for acting without integrity, and then SECAP charges you, and then SECAP prosecutes you, perhaps the fact that you were pushed could just be a mitigating factor when it comes to sanction. But it is not a defense. You cannot raise it anywhere to say, okay, I lost my integrity because I was being pushed to do such and such. I hope this provides clarity, Mr. Muloi. Thank you, Program Director.
Oh, no, thanks, Mr. Matebula. Thanks a lot. Yeah.
Thank you, Mr. Matebula. Do we have another question?
Oh, yes, yes. One delay, Patrick, you can come in. Patrick, you can come in.
Okay, morning, everyone. I have two questions on one of the rules. The first one is that you are saying that we need to give a reasonable time to the client about the approval of the plan. But what confuses is that we are entirely not depending, it's not depending on ourselves to confirm that time, because you can confirm the time that the municipality is running around with whatever application that you need to be approved, and town planning issues get in when we are still submitting the plan. Therefore, how can you help us to confirm the time, because we can't confirm the time of the exact time that the plan will be approved at. And it still sometimes become unreasonable, because sometimes it does take 3 years the plan to be approved, because you submit a plan and they take their time to approve the plan, and on top of that, the issue of campaigning comes in, and it ends up frustrating you, finding that the plan takes long to be approved. It's the first question that I want to ask them. How do you help us? How does the SACAP help us with saying that we need to be accountable for reasonable time for the plan to be approved? And the second one is that the plan, the document, the plan, the work that you have done, you need to keep it for 5 years minimum. Therefore, you find that the client doesn't build the plan or doesn't submit a plan. Remember that you can't force them to submit a plan after you have drawn it. And you decide to submit the plan after 7 years after you've drawn the plan. Therefore, what do you do with that situation? Because you expect me to keep the work that I've done for the 10 for 5 years minimum after the completion of that thing. How do you deal with that two issues that I've asked? Thank you.
Thank you. Mr. Makakabule, can you come in?
Apologies. I'm busy with the comments on what is this? On live comments. So can you please repeat the question, sir?
Okay. I'm saying we have a challenge to give a surety to the client that how long will it take the plan to approve? Because we entirely not have the power to confirm that, because you tell the client this will take 2 months, end up taking 3 months because of the to and fro of the municipality. Sometimes they lose your file, sometimes they lose all those things. They didn't attend all those plans. Even though they have approved, they've introduced the online, it takes time to approve, because you find that more than 10 people have commented on an plan with different comments. You receive that comment, still it's not approved.
Okay.
And on top of that, the company issue kicks in while you are still trying to submit the plan. That's what I'm saying. It's possible the plan to take 3 years. Therefore, to the client, it's unreasonable for her plan to take 3 years, or her plan or his plan to take 3 years. But it does happen that the plan can take more than 3 years, because if they say that you need to do a consent, after consent they'll say no, USCP. All those things, they take their time. Plus minus 6 months each for consent for SDP to approve by companies. Therefore, we have that issue. Therefore, I'm saying that what are we going to do if we have that situation that the plan can take more than 3 years to approve? It's not entirely up to us to push the municipality. And the second question is that you said the plan, the work, we must keep the plan more than minimum 5 years in our archives. Therefore, what if the client that doesn't want to approve the plan? Sometimes it can take 5 years for him to tell you that no, I'm ready to approve the plan. And that issue of keeping the work for 5 years, and that means for 7 years plus 5 years, that means we have in plus minus taking it to keep the work that we have done for the plan. Therefore, what do you do with that issue that comes on that archiving 5 years for the work that you have done?
Okay, thank you. I'll start with the first question. You have indicated that you have submitted plans to the council, and that you are worried about the time period or the agreed period. So obviously, if you have agreed and be frank with your client to say, I'm going to submit these plans, and then you have prepared the plans are ready to be submitted, and then you submit the plans. So on your conduct, what we are trying to say is that your conduct must be ethical. So this means that you would have prepared the plans, and after preparing the plans, you would have submitted the plans timeously to the municipality. If there's any delay, it should not be on your side. You would have done what you need to do. If we are saying that, no, please respond to this complaint, you submit to us the plans that you've prepared. You submit to us the information that you have, your correspondence with your client to say, I have submitted the plans and the plans are submitted on this date. So if there is any act of misconduct, it should not be on your side, because you would have done what a normal, a reasonable architect or registered person would have done. So if the delay is on the municipality, it should be seen as the delay that is on the municipality, not that we should say, no, you should have this, how can I say it? Because, okay, you know where you submit plans, and you know what are the challenges with your municipality or local council. And as SECAP, we do on a regular basis have a workshop with the municipality, trying to engage with them to stress this issue of saying that our RPs are having challenges with approval plans. You're taking time to delay. And then even this system of online submission, it was also with SACAP's intervention, wherein we needed to work with municipality to get to a point where all these things can be on record, and we can see if you have submitted it online, we will see the submission date, and we'll also see the comments. And then from there on, we'll see the comments as to, are you attending to the comments? If you have attended to the comments and the municipality is taking 8 months, that is not on you. That is on the municipality. So you do what you're supposed to do and inform your client to say, I have submitted the plans are submitted, they're with the municipality, and the municipality is assessing the plans, and they're circulating. I'm waiting for their response. So it should not be that the municipality is delaying, you are delaying, and then the client comes. So on the other issue of keeping records, so the rule says that shall keep all plans, record certificates and or drawings commencing from the start of work and up to a period of 5 years from the date of final completion. So this final completion is very much important, from the date of final completion. So it means that when the plans have been completed or maybe your appointment has been completed, you keep those records for 5 years after that date of final completion. I think that makes sense. Thank you.
Thank you.
Well, I'm not answering the last one. What I'm asking is that the completion of the structure or the completion of the plan, which one are you referring to?
Completion
After
of
the bidding special.
This would be completion of your of your appointment. Remember, if you are appointed for stage 1 until stage 4.1, it means that you have gotten the plans approved. So if you have completed your appointment of 4.1, getting the plans approved, it means that is on you. Not to say, because sometimes you might not be there. Let's say if you complete the plans, if you complete the plans are approved, and then your client decides not to build, it will be unfair for SACAP to say that you have failed to comply with the rule, because now you have complied with the rule by making sure that your final what you have been appointed for, and then the final stage of what you're appointed for is this date. The plans were approved, and then you keep them for 5 years. So if the client doesn't build, so it means that you are going to be keeping those plans for more than 10 years. It means that you must be attending to all those houses to make sure, no, the completion of your stage or your work stage, you complete from stage 1 to 4.1, and then from there on, you take it from there. Thank you.
Okay. Another question that I want to ask you: the record that I'm keeping, is the plan that has been approved or the one that is not approved? Because they give me as one copy of the original, and then we give it to the client. That means I need to scan and have the copy of the approved plan, or you mean the plan that is not approved?
Okay. When you are appointed by your client to prepare the plans and get the plans approved, right?
Yes.
So in the event that your plans are now approved, you have an approval stamp. That is the document that we are referring to, and any other document that might be in relation to. Because if you read the code, it will make sense. Let me read it back again for you, so that we are clear. So this would be, so it says, shall keep all plans, records, certificates, and drawings commencing from the start of the work and up to a period of 5 years from the date of final completion. So it means that your work stage completion. Do you get me? So it means that your records, your certificates, and all the plans, whatever that you have, because you can't, we can't hold you to something that you are not in control of. Thank you.
Okay.
Thank you, Mr. Makakabule.
Yeah, thank you, Chair. It's now Samuel Junior Jeche and Temba. Then we will try Dion and find out. If not, we'll then remove him to speak. So Samuel Junior, you can come in. Temba, you can come in before we take others too.
Good day, ladies and gentlemen. Thanks for the time. I would like to ask this question. I hear that you've been highlighted, but yeah, I need a clarity on that. If I'm having a lower registration with SECAP, and then yeah, I want to prevent myself to getting myself at the wrong side of the code of conduct, and then I would like to amalgamate with a senior person. So in that case, we have to register a company So like when we having the client, the payment must go through that company or not, or I have to appoint him on my behalf, because the client, it is my, but because as I'm limited due to identification of work, I'm not allowed to perform that is such a scale of work. And then what is the way forward going on that one? And then the other one is, I am allowed maybe to share a project with another architect. Let's say in argument's sake, I did a project for the client, and then I did everything, the plan, it was approved. Maybe after certain years, the client maybe sold the house, comes someone, and then he want to do maybe addition and alteration. Maybe the other architect calls me, can you please send me your DWG, because I was appointed to work on this project. And then I would like to, I don't want to start from the scratch, just I want to do an alteration.
Okay. Okay, thank you, Mr. Samuel. I just need to establish your category of registration so that maybe I don't mislead you. But in terms of your first question, if you want to open a practice with another registered professional, that is allowed. So what Rule 5 prescribes is that when you name your practice, that's where you need to be careful, because if you are a draws person and then you are the majority shareholder in that practice, but you go and you name your practice Samuel Architect, that is prohibited. Because as the majority shareholder of the company should be named as Samuel Routing Services, for instance, rather than Samuel Architect, where else you are not registered at the higher hierarchy as a professional architect. And Ms. Tope will just add on.
Thank you, Program Director. In relation to the first part, yes, it's very interesting for us to know your registration category as mentioned. But what is really important here for you to understand is that if you are in a lower category of registration, you are limited to doing work for that lower category of registration. I'm not happy when you are saying, what if you have a client and then you want to work with somebody who's in a higher category of registration because you have a client? You shouldn't have that client, because that is not work that is within your category of registration. You are only limited to doing work for your category of registration. So if you are a draftsperson, you should only be involved in the business of a person who is registered as a draftsperson. You can't be meeting clients and accepting level of work that are outside your category of registration. So I think that is what you really need to understand, so that it avoids the issue of you saying that, do you now need to get, you have a client, now you need to get somebody who's in a higher category to work with. However, as said by the program director, it's not a contravention of the code of conduct for registered persons to establish an architectural practice. But the issue here is, it's very obvious when we are doing an investigation that you are the one who's actually getting work for work outside of your category of registration. You are either involved in the drawing of those plans in order for the person in the senior category to sign off, whereas according to the IDOW and the Code of Professional Conduct, it is that senior person, the person in that senior category, that should be dealing with work of that category. And then we can go to the second question. In relation to the second query, I'm not sure if I should proceed with it as well, but you did mention about where you have prepared building plans for the client, and then those plans were approved, and then now the client has appointed another person to do the work, and said professional is now approaching you and requesting the CAD file or the CAD drawings. In general, as the person who prepares the building plans, you have a copyright over those plans, and then obviously your copyright, copyright vests in you. Therefore, it's not, unless there is an agreement between you and the client from the start that you will provide your copyright, or you will sign over your copyright to the client. There is no need for you as a professional to share your copyright with any other person. However, this shouldn't be used now by registered persons to prevent clients from obviously appointing whomsoever they wish to appoint for architectural services. So usually when a person comes to SACEP and says their client has, they have a client, however, they don't have copyright of the plans, we will obviously suggest that they should take steps to not prevent, to not contravene the other professional copyright. Thank you.
Thank you. Thank you. Thank you. Yeah.
Okay, Chair, we have
Yes.
Temba, Samuels, Makina, Naido, and Sepo in this line. So Temba come through, followed by Samuels, followed by Makina, Naido, and Sepo in that order, please.
Yes. Let's try to keep the, sorry, before you speak, sir, let's try to keep our questions short because we are running out of time. We will try to answer your questions as briefly as we can and comprehensively so. And then if we can't get to your questions, you can send our legal team an email at legal@sacapsa.com. But you can go ahead, sir.
Yes, morning everyone. I just want to check something here. How do you deal with a scenario whereby you have been advised by a certain individual who is in an adjudication for a specific work under a certain company that your qualifications and registration were used without your authority? And the fortunate part is you are aware of the company. How do you deal with such? Thank you.
Yes. You must bring it to SACAP's attention at legal@sacapsa.com. Then we will do a preliminary investigation, and obviously we will let you know what is the outcome. So that one, it's an investigation, so we'll have to investigate. Thank you.
Okay, no, thank you. But I will you if I do a write-up, will I have to specify exactly the names, everything, or I should just give more like a lead towards the whole process or the other company?
We need details, but you can send an email, then we'll take it from there.
Okay, no, thank you. Bye.
Thank you. Samuels, you can come through.
Mr. MC, I think we've had a question from someone already. I think
Okay.
it's yes.
Okay, Makina, you can come through.
Thank you, and thank you for the opportunity to speak. I just want to emphasize that we really appreciate SACAP and everything they do to protect us. I'm in a situation where I just discovered that somebody submitted plans using my details. And I picked it up because City of Cape Town updated their portal. So the new one was able to show me all the things that were submitted in my name. I picked it up and I reported to SACAP. And of course, after reporting to SACAP, the municipality kind of withdrew most of the submissions. But then they told me that the ones that had already been approved, they can't do anything about them because they were already approved, which is frustrating me. I feel like surely, because now they know that those things were submitted fraudulently, they should withdraw everything. But I can tell you now that there is one that now apparently is showing that work has started. And they told me they can't stop it because it was already approved. I don't know how SACAP is able to assist us in such a scenario. Thank you.
Okay, with that one, since you have submitted a complaint to SACAP, I believe already it's with our investigators. and they will reach out to you and also to reach out to the municipality to find out the reasons why they are not withdrawing all the plans. And obviously we will contact you in that regard.
Thank you.
Thank you.
Okay, Chair, through you, it's now Naido, then the last one will be Tsepo.
Thank you.
We can't seem to have Naido. Tsepo, you can come through.
Well, thank you very much, Chairperson. My name is Tsepo Befole, and perhaps I just need to state that I work for the state, which will explain to you why I'm asking the type of question I'm going to be asking. I've got two questions, Chair. The first question is, I find that the code of conduct and many of the documents that we have, that the council has, are mostly biased toward regulating work that is being done in the private sector. But it makes it a bit difficult for us, for those people who are practicing within the public sector. Take, for instance, any one of the professionally registered persons who are working for the state or who are candidates working for the state. What is their rights? Where do they start? Where do they end? So I find I'm subject to correction, maybe if I'm not aware of any other document that deals with that, but really there is that bias. The second one is, I don't know to what extent the council participates in the various fora that the Department of Public Service and Administration sets up. Because what you find is that, I'll make an example, in my space, which is the education sector, when the Public Service and Administration Department puts in place various regulations, it excludes the utilization of other categories of RPs, and that is improper because it's totally not in line with the acts, particularly our act in this particular instance. So what I want to find out is whether the council, does it participate in that? If it does participate in that, is it the reason why when we generally look at the code of conduct, it does not deal with those that are in the public sector? May I get clarification in that respect? Thank you very much.
Thank you so much, Tsepo. With this one, it will be with regard to Rule 1, because it's more of a general, and which I think is applicable to all registered persons. Mr. Matebula, can you please assist?
Thank you, Chairperson. Chairperson, I'm still trying to figure the question specifically. In as far as it relates to integrity, if I may ask our RP to just repeat that specifically with integrity.
Okay, let me try to assist the RP then. Okay, Mr. Tsepo, when you look at the code of conduct, it is applicable to all registered persons, and it does not specify whether you are practicing in the department or in the government, but it applies to you as an individual. So the reason I was referring you to Mr. Matebula is because Rule 1, its entirety, it refers to the integrity of you as a registered person, irrespective of in which sphere of practice you are, whether you are in the private or whether you are in the government. But where I get your comment, where you pick it up from, is that mostly we address registered persons who are in the private sector. And your comment I noted, but the code of conduct is entirety. It applies to you as a registered person, irrespective of where you're practicing from. And then in terms of your second question, I note that there is the IDOW. So the IDOW came into effect, and then it states that there are categories of registration. So the IDOW specify which work who must do. And in that instance, it states that you should not be discriminated based on the category of registration that you are in. If you are a draftsperson and then the project relates to what the IDOW says a draftsperson can do, you should be included. You should not be excluded based on your category of registration. Obviously, for us to look at those documents, you will have to send us an email so that we can look at the documentation and then look how exclusive it is in terms of other categories of registration. And as I've stated, our email address, it's simple, it's legal@sacapsa.com. Thank you.
Chair, I'm sure, or probably let me just give the last chance to Vivian, Smith, and Dion. Then we close the session, the question session.
Thank you.
All right. Okay, Vivian lowered the hands, then Dion. All right. Okay, I see you, Mr. Moloi, but we will come back to you after these presenters who are about to present right now. So, Chair, you can proceed.
Thank you, Mr. Minetti. Thank you, fellow registered persons for your questions. We believe that and we hope that we've addressed them comprehensively, and then now you understand. So because our webinar also continues, we still have two presentations that we need to go through, and then we've been sitting here since 9 o'clock. So I will give you a body break for those who have been sitting so that you can go to the bathroom. So I'll give you a body break of 15 minutes. On my clock now is 25 minutes past 11. So if you add 15 minutes, then it means we should be back at 11:35. So let's be all back at 11:35. Let's just go grab a cup of coffee, have a glass of water, and come back at 11:35. Thank you.
Over to you, Chair, we can start.
Thank you. I'm back now. You can see me. So we are continuing. Thank you for staying. We are continuing with our code of conduct webinar. So I will be taking you through the next presentation, and I will be focusing on the various misconduct. So in terms of this, it's just the misconduct that my colleagues did not mention, that we find that they are mostly contravened by our registered persons. So by our registered persons, we also refer to our candidates. So I will be focusing on candidates. I believe that if you are a candidate, you are considered as a registered person, but not a registered professional. So I will be addressing candidates on Rule 2.6, and then I'll also be addressing Rule 6.3 and Rule 3.4. So if you allow me, I'll move to Rule 2.6. Okay, what Rule 2.6 states is that a registered candidate must perform work under the direction, control, and or continuous supervision of the registered professional entitled to perform such work, and who must assume responsibility of any work performed by the candidate. If you may recall, one of my colleagues did touch a little bit on this, that as a registered person or as a registered professional, you are accountable for your candidates. So what I'll be doing is I'll be taking you through the type of complaints that we receive that refers to candidates. Okay, in terms of Rule 2.6 is that there are instances where members of the public contract candidates without knowing that they are candidates, because candidates misrepresent themselves. They misrepresent and say that no, if a candidate is a candidate architect, they misrepresent themselves and say that no, I'm an architect, I'm not under supervision, I can do this work for you. So what we are saying to candidates is that if you are registered under the category of candidacy, you must ensure that your mentor is aware of all the projects that you're doing. So we usually see it as candidates try to do side hustles that their principal don't know about. So if you are a candidate and you are found to be doing a side hustle without your principal knowing, you will be found in contravention of Rule 2.6. So this one is to say that if we receive such a complaint, we refer the complaint to the registered mentor to check if the registered mentor is aware of this project. And then if the mentor is not aware of that specific project, it means you as a candidate, you were working independently without your mentor knowing, and therefore you'll be found guilty of contravention of Rule 2.6. Imagine you are found guilty of a contravention of the Code of Conduct, you are not even a professional yet. So what we encourage is that if you are registered as a candidate, please make sure that your mentor at all times is aware of your whereabouts, is aware of the project that you are working on, because you will be found to have a misconduct before you even qualify as a professional, because this file, these complaints, they stay on our file for a very long time, and then it can tarnish your name for something that you could have just checked with your mentor if you can do such a project. So I'll move on to the next contravention, which is the contravention of Rule 6.3 and Rule 6. So in terms of Rule 6.3, it provides that Rule 6.6 of the Code of Conduct provides that registered person shall comply with the National Building Regulation and Standard Act, Town Planning, National Heritage Resource Act, and any other built environment laws or any other applicable law governing the work. So what you need to take into consideration when it comes to this rule is that we are not self-governed. So there are laws that we need to comply with. And what we've seen at the legal department, okay, I'm trying to move to the next slide. Okay, what we have seen at the legal department is that we are receiving complaints from members of the public saying that I contracted so-and-so to do work for me, and then so-and-so did the work for me, and then they gave me the plans, and then they advised me that I should continue or I should commence with construction. So what the National Building Regulation and Standard Act states is that there should not be any erection of any building plan of any building without approved plans. So by you advising your client to commence with the construction without approved plans, you are not only contravening the Code of Conduct, but you're also contravening the National Building Regulation Act, because it states that there should not be any erection of any building without approved plans. Okay, I want to move to the next slide. Just I think technology is failing me. Okay. Okay, just to emphasize on rule 6.3 is that if you are a registered person and then you are found to have advised your client to commence with construction without approved plan, you'll be in contravention of rule 6.3. So there are instances where you advise your client to commence with construction with the hope that the plan is almost approved. So you should refrain from doing that, even though the plan has been submitted. As long as it has not been stamped as approved yet, you should not advise your client to commence with construction. Instead, what you should do, you should advise them not to commence with construction up until the plan is approved. So how you can protect yourself from contravening this rule is that when you communicate with the client, whenever you are updating them in terms of the plan, you must always advise them that the plan is not approved, therefore construction must not commence. So in that way, we will have a paper trail. Should the complaint come to us, you will have a paper trail where you have writtenly advised your client not to commence with construction. And I also look at rule 3.4. This has been coming to our attention lately. So I'll just read the rule so that we can go through it. That rule 3.4, it says registered person shall not use architectural work prepared by another professional without written authority from the originating professional. So I'll give you instances of how usually this occurs. There are instances where you are registered as a draft person, and then there's also someone registered as a professional architect. So there will be instances where they will ask a professional architect to prepare plans. A client will ask a professional architect to prepare plans for them, and then after they've done the first few stages, then they will ask a draft person to go and submit the plans with the intention that they will have the expertise of a professional architect to prepare the plans, and then thereafter they will ask someone registered in the lower category with the impression that they will get a lower fee from someone who's registered in the lower category. So what we are encouraging is that if you happen to receive a half-done plan or a half-done project, inquire with the previous registered person. Are there any disputes arising from this project? Because you don't want to find yourself accepting a mandate from a client where else they have not paid the previous client. So as much as we need to be protecting each other as professionals, you need to also to ensure that you protect yourself against any legal actions against you, because now you are accepting a half-done project, and also you are taking over a work that is not like it's the work that is half done from someone who has a dispute. So what this rule requires of you is that ensure that the originating professional is in the clear. There is no dispute resolution. There is no dispute whatsoever between the client and the originating or the previous architect. I believe that as registered persons, we work together. So, but you can see when someone gives you a half-done project, you can see where there's a problem. So if you see that there's a problem here, inquire with the previous originating professional to make sure that you are in the clear and then you're not found to be contravening any rule in the code of conduct. So since now I will be taking it to the program director, so I will take it back to her and then she will take over from here. Okay, so from here, thank you so much for listening to the presentation. I hope you have learned. I hope you are taking notes, and I hope you are writing your questions on the site. So for our Q&A, so that we can address the questions. So now we are moving on to our next presentation. The presentation will be focusing on the contravening of our Architectural Profession Act, specifically Section 18.2, read with the Section 26 of our act, which is Act 44 of 2000. So the person that will be taking us through the next presentation will be Mr. Nyaka. He is our investigating officer, which deals with this contravention of the Act, specifically with criminal acts. So he will be taking you through what SACAP has done in terms of making sure that we are presenting the profession to those who are registered, and then he will take us all through actually also section 18.2 of the Act. So I will take it over to Mr. Voyonyak.
Thank you, Program Director, and greetings to everyone. I'm not sure if I should introduce or reintroduce myself, Program, but I feel like I must reintroduce myself. My name is Vuyo, and my surname is Nyaka. I am the investigating officer of the council. I am dealing strictly, like she said, with unregistered persons, which is those that are performing while they are not registered within the council. I'll be taking you through on my table of content. You'll see there's 3 sections which are intended to protect the profession as well as to protect the public, which is section 18.2, subsection 2, which is read with section 26, subsection 3, as well as section 41, of the Architectural Act, which is the provisions. License to practice on my second slide. We are all aware of section 22 of the Constitution, which grants every citizen rights to free trade as well as to free profession. However, it needs to be regulated. So that's where we come in as a council to regulate the profession, which is for the purpose of this meeting, the architectural profession. In one of the sections, which is section 18, we'll be talking about section 18.2, about a person where a person may not practice in any categories contemplated in subsection 1 unless he or she is registered in that category. That will be section 18, subsection 2. Section 26, subsection 3 is of the Act. A person who is not registered in terms of the Act may not use any title referred to in section 18 and 21. And the titles are reserved for registered persons only. Section 26, 3, 26, subsection 3, B and D of the Act. A person who is not registered in terms of the Act may not pass himself or herself as a registered person. Then we go to section 41, which is the provisions, which is a person who contravenes the above Act, which is section 18, subsection 2, and section 26, subsection 3, may be found guilty of an offense of contravention, of contravening. We as a council, we have received a number of complaints of the persons that we are performing or rendering architectural work. However, they are not registered within the councils. They are misrepresenting the public, taking money from the public, and leaving the public stranded and with incomplete works. It is therefore a requirement to pay an annual fee to SACAP in order to legally perform the architectural work. On the second column, which numerous complaints relate to unregistered persons performing architectural work using registered persons details to deceive members of the public. Unregistered persons are not only a concern to public safety, they are also bringing the architectural profession into disrepute. I think my colleague have mentioned on rule 5.6 that a registered person shall not, unless they enter into any professional association with an unregistered person, unless the permission has been granted by the council. I think this goes back to say that whenever there's an association that needs to be acknowledged by the council, which is, an application should be made to the council to have such association. If there is no such application or permission from the council, we do not recognize such association for those registered that are in association with unregistered persons. And for those that are performing while they are not registered, we as the council do not have jurisdictions. However, this is what we do when we receive a complaint of such nature. We will investigate it internally. Once the investigation is at the final stage, we refer the matter to SAPS for further investigation. Remember, some of the things we don't have access to them. So that's why we will do the preliminary investigations. Once that is done, we refer the matters to SAPS for further investigations. We have successfully opened a number of cases, I would say now in about 5-6 provinces of unregistered persons. And we have recently, that was 3-4 months ago, we have recently have the matter that was finalized before the Johannesburg Magistrate Court, where a person that was performing architectural work while he was not registered, he was found guilty and was sentenced into a 5-year suspended sentence for an option for 20,000 rand, which was wholly suspended. We still continue to publish those that are not registered on our Facebook page. Some will come forward to come and register after their names have been published, which we are also encouraging. We are also going around the provinces, trying to engage with NPA, the police, since our cases were not receiving attention, but now there is a movement. If Mr. Kondwan, I can attest to that, because I was sitting in Cape Town, we opened a case and we sent an email to the city of Cape Town. There was a progress. In fact, there is still a progress. It's just few things that needs to be sorted out. I believe from my presentation, that would be the end. Thank you, Program Director.
Thank you, Mr. Nyaka. Maybe the question to our registered person will be like, why are we being presented with this? This is just to make sure that you are aware of what will happen to you should you continue to practice without paying your annual fees. Because if you fail to pay your annual fees, your registration will be cancelled and then you will be seen as an unregistered person. So if we receive a complaint from a member of the public, and then we find out that at the time when you were performing that work or when you were accepting that mandate, you were not considered as a registered person, that matter will be referred to Mr. Nyaka. And then as you have seen on our social media, we are on the ground. So if you are found to be practicing while you're not registered, you will be arrested and be sentenced for practicing without being registered. So let's just make sure that at all time when we're accepting mandates, we are duly registered, we are on point with our annual fees, and then we are active to practice with SACEP. So that will be the end of the presentations for today. And then we thank you so much for being in attendance. And then we will be taking questions and answers shortly now. And then also remember, there will be a set of questions that will be emailed to you. Please respond to those questions because they will help us to know and understand how much did you take from the presentations, and then where do we need to fix and where do we need to focus on. Please respond to those questions that will be emailed to you. So we will be taking questions, Mr. MC.
Okay, Chair. We'll start with Selo, Clement, Vivian, then Samuels, Carl, and Mr. Muloy. In that order. Go give them access.
Yes, Samuel. Can we move to the next available one, Mr. MC?
Silo Tsotetsi, you can come through.
Good morning, and how are you, sir? Good
Yes,
morning.
we are good. Yes, we can hear you. We are good. How are you?
Yeah, I'm okay, ma'am. I just want to ask a question here on the process of the approval of the plans, because now we're having a problem with our town council, especially in Niger. Because now when we submit the plans, now they take too long. Then when you go to their offices, sometimes they are closed. Then when you phone them, they don't answer the phones. They'll tell you more about the load shedding. When there is a load shedding, for example, if the load shedding started at 10, maybe then the electricity come at 12. From 8 o'clock, they are not there. Then you go there maybe at around something like 1. They are on lunch. How can you go on lunch and yet there was a load shedding? So we have a problem with that. We end up fighting with our clients, you know. Then I don't know, how can we tackle that, or where can we report that that kind of a person who's not responsible?
Okay, thank you for your question. What you need to do is that you need to send an email to our stakeholder relation. Mr. Masango is your guy. So you need to send to Mr. Masango detailing exactly what's happening, giving the details of the municipality, and then Mr. Masango will be able to help you. So Mr. Masango, you can send him an email. You can send the email to legal@sakapsa.com, then we'll forward it to Mr. Masango. Thank you.
Okay.
Yes.
Okay. Can I ask another question?
Yes, yes, you may. Yes, you may. We can hear you.
Yes, you know, where we submit the plans, especially the lady, the one who's receiving the plans on the reception, she's also drawing the plans. So, you know, when I send my clients to get the plans of the existing building before I can start with the plan, then she usually takes my client and draw the plans for her. So I don't know whether is it the right thing for someone who's working for the town council to draw the plans also?
No, it's wrong for them to draw plans. They need to get permission from the employer. So we have dealt with a similar case that you are referring to. So what you can do is that, because we need to investigate it, you need to send us an email so that we can see that we engage the municipality, because we have dealt with a similar complaint before.
Okay, okay.
Just send an email at legal@legalsa.com.
Okay, thank you so much. Thank you.
Thank you, Mr. Tsotetsi. Clement Mia, you may come through.
And the external spaces. And then simultaneously, again, the threshold between the private external and this beautiful landscape around us that makes this house.
Mr. Muloi.
Yes, yes. How are you, Dogozo? Is that Dogozo?
Yes, sir. I'm super
Yes,
fine. Thank you.
I'm okay, Dogozo. Again, thanks for giving me the opportunity to ask some questions. There was a concern from Mr. Tsepo Pefulo, who's working for a State Department, and from what I've gathered is that he was not properly answered. I'll just follow up on his comments, on his question. One thing is that the State Department tends to implement what we call panels. And on those panels, sometimes they have a panel of engineers. And when the project needs an architect, the engineer will be responsible for appointing an architect. And it becomes a very difficult exercise whereby the engineer will just appoint anybody without looking at the category of registration. I've come across these situations since being the president of a voluntary association, whereby a department will appoint a quantity surveyor and a quantity surveyor appoints a architectural professional. And looking into it, and I found it. Somebody's disturbing me. So, hello, program director. Somebody's talking. I was saying.
Mr.
Yes.
Ndogozo, can you please mute Mr. Nia Clement? Can you please mute? Thank you.
Yes. Now, sorry about that. And Mr. Tsepo was trying to raise a question regarding that, and my follow-up question is that how is SACAP monitoring these panels, whereby a panelist has appointed another type of professional consultant, which appoints an architectural professional, and they don't look into the category of appointment. I've come across several of these, and according to sub-rule 3.4, which was just presented now, it is contravening the act to appoint somebody at a lower category to do the project, which is supposed to be, let's say, for an example, implemented by a higher category person. That's the first thing. Going back to Mr. Vuyonyaka as an investigation officer, I would like to give you a task, Mr. Nyaka, to investigate this flourishing online firms. I did. There was a time where I called one of them and asked who's an architect, and the person say, I'm an architect. And when I checked his name, he's not an architect. It's not even a trust person. I'm giving you a task, Mr. Nyaka, because I see this needs to be investigated. These people are just taking our jobs. Yeah, those are the two comments, two questions that I would like to suck up. The other thing which I've noticed, as a voluntary association, we now see that our code of conduct as a voluntary association needs to be a sub code of conduct under the SACAP code of conduct, because now the compliance needs to go back to SACAP. Thank you for the time.
Thank you. Thank you, Mr. Mloy. To your first question of appointments, even though it's out of the code of conduct presentation, I will attempt to answer it best in this way. So the state wherein maybe we'll be looking at a certain department who is let's say they have a project that they need to do, and then they have appointed, or in their employment they have engineers and architectural professionals who should then appoint other professionals to perform such work. So that is not, I don't think it's under SACAP's watch, but in terms of appointment of who, by who and who. But however, all these professionals, in terms of the code of conduct, let's focus on the SACAP, let's focus on the architectural professionals. So they are reminded to uphold the code of conduct in whatever jurisdiction they may hold a post on. So let's say he is a chief architect in a municipality. He is still obliged to comply with the code of conduct. So let's say if you have found that, no, this one is an architectural professional, and in his employment as a chief architect at a municipality, he has failed in his professional duty to appoint a person who is let's say registered for that matter, or who is who must in terms maybe in terms of the identification of work perform such work. You can lay a complaint with us, and then we will investigate on that basis. Let's say if it's an engineer, I'm sure even the AXA will be we will be happy to investigate on their side if there is what is it, an act of misconduct that has been, or that has been alleged to have been committed by an architectural professional in his respective professional how can I say it, duties. Yes. So in terms of 3.4, you highlighted 3.4, unless if maybe we are not, because the rule 3.4 talks about the use of another architectural work. So it says here that a registered person shall not use the architectural work prepared by another professional, by another registered professional without written authority from the originating registered professional. So this is rule 3.4, where you find someone's work and then you take over that work without informing that professional, and then you continue using that work. So that on its own, like I've indicated on the presentation, that you might find yourself having to be having been sued by another architectural professional that you have infringed on their copyright or also on their intellectual property, because you are using someone's work that they have prepared. So in terms of the code of conduct, you must inform that person's or you must inform the originator of such performance of such work, and then he will then give you permission if you should use them or not. So I think you were because you indicated I think you were talking about a lower category performing work, collaborating with a person on a higher category. So look, the identification of work is out there for professionals to adhere with. So you look at the identification of work. Is my category of restriction aligned with the work that I'm doing? If it is not aligned with the work that you're doing, it is not a misconduct for you to work with another person. Let's say another category of registration, which is on a higher, let's say a draftsperson working with an architect, because that is what is happening on a daily basis. Architects have hired draftsperson. Yes, that can happen. So what you are saying, or maybe what I understood, was that Tom gets, Tom is a draftsperson, he gets a job to do work of which he is not allowed to do in terms of the identification of work. He goes and then he says, no, I'm going to be collaborating. It is, what we are saying is that the architect can approach you to do the work. Not that you approach the architect to say, no, let's work on this, because I had someone saying, no, because it's my client. Even if it's your client, if you're not allowed to do that work, you can't do that work. So it's easier, we follow and comply with what we are supposed to do as category, as per the category of registration. And then the architect will then, in their office or however, they can, in association, as long as the person is registered, have that kind of association. We're not saying that draftsperson should not perform work. No, they can perform work under their category of registration. And if they're performing work which is not under their category of registration, at least a lead person must be the one who is higher, wherein he is the one who's taking responsibility. And then that can assist you wherein you have to do what you have to upgrade for your portfolios and as it goes. Thank you.
Thank you, Mr. Makakabule. We will take the next question.
Program Director. The next question we will take Carl. Carl, you may come through.
Good day, can you hear me?
Loud and
Yes,
clear.
yes, we can hear you.
Welcome to all the webinars, Zoom meeting, to those that are taking part. 2 or 3 things that are really concerning to me, and I think it concerns many professionals, you know, within my category and then the category higher, regarding to the SACAP fees. And firstly, the SACAP fees is that why do the draftsmen have to pay the same amount of fees as what the architect pays, but yet we are restricted by the RDOW? Secondly, one of the ladies here, I just can't remember her name, mentioned that when you are suspended, you know, on your account because of not paying your fees due to circumstances, financial circumstances, and as we all know, work is not easy to come by with our economy, you know, that is struggling. It does become a challenge, you know, to uphold your commitment to the SACAP fees. Now, when you're suspended, you know, for not paying the SACAP fee account, and now all of a sudden a potential client comes through, and now you're desperate because you need money, you need to survive, you need to eat. And now it was said that you cannot go into agreement with a client if you're suspended on your fees. Now, how do you pay your fees, you know, to be registered or to be recommissioned, and you are bound by the code of conduct that you're not allowed to engage with a client, you know, to provide a service? So that is still, you know, the concern that I believe myself and many professionals are having at this current moment. And yeah, it is very much concerning. And I hope you guys can answer me on that part.
Okay. Yes.
Thank you, Mr. Khan. Well, I saw I attempted to answer the question on the chats. The payment of annual fees as it's I think it's self-explanatory that it is a requirement to pay on an annual basis. And then before you are suspended, SACAM informs RPs of such before they suspend. So we do not just suspend RPs without informing them. So during that time, it is a responsibility of RPs to make sure that they are their membership is up to date. So this would obviously suggest that you are saying, no, I can be collecting money during the time that I'm not performing architectural work, but I'm just collecting money. No, let's focus on paying the annual fees in time, so that we should not be found having been suspended and having excuses of why we are suspended, because the annual fees, you've got the whole year to pay the annual fees. Or to arrange to pay the annual fees.
If I may interrupt, I think we're missing each other on this part. Like I said, you know, our economy is struggling at the moment, and when you do not, I'm just using a random example. If you do not get to work, you know, for 3-4 months, you know, because of your city's experiencing challenges or whatever it may be, it's not that you do not want to commit, you know, or to paying your fees or not paying your fees on time. It's a matter of, due to circumstances of political instability, you know, on all other type of scenarios, that's leading to you not able to, you know, make the payment. Now you are, you know, hoping, you know, or praying, you know, that the next client will come through so that you are able to survive and you're not able to put food on the table. Now you're left with a choice. Okay, right, I had a very bad year this year. How does one, you know, you need money. You need to, like we all do, we all need money to survive. We all need money, you know, to keep operating. But if the circumstances in your province or your city or whatever leads to the fact that, you know, you have not been getting work, you know, for the past few months, now all of a sudden you get a potential client. Now you're not registered or you've been suspended. How do you, you know, find balance in that part? You know, now It's not that you don't want to pay the fees, or I mean, how do you arrange with the person by the call center that you're phoning and say, listen, I don't know when I'm going to get work. I don't know what's happening in the future, but I managed to get a potential client. But now I can't, engage with a potential client with agreement simply because of the code of conduct. So that's a concern, that not only myself, that many professionals are having right now.
No, I understand you. I understand you, Mr. Carl. It's unfortunate that it's not only the code of conduct, but also Mr. Vuyo there, wherein you are found to be practicing without being registered. That's what it do. It's just unfortunate. But maybe this one we will attend to it on a different platform, Mr. Carl. But on our side right now, currently the position is that let's pay our registration fees and annual fees on time, so that we should not be found to have been practicing without being registered. I think that is the position that we're holding, or SACAP is holding right now. Thank you.
Okay, but I understand what you're saying, but you're not providing me a solution to what I'm expressing. You're not providing a solution to the professionals that are experiencing the same scenario. And I just find SACAP needs to find a balance or some kind of a safety net, to help those professionals that are in that predicament.
Yes, thank you, Mr. Kyle and Mr. Makakambule. Just to avoid a dialogue, with regard to what Mr. Makakambule has said, is that the code of conduct standard is to say that you need to pay your annual fees annually. So should you have any difficulties, it will be treated obviously on a case-to-case basis. So you will have to engage with our finance department to find out if they will have an exception for you. So we hope that you've been answered, because it will be treated on a case-to-case basis. We can't drive away from the code of conduct, because of the requirements by the code of conduct, and not just the code of conduct, and also our act to say that in order for you to be considered as a registered person, you need to pay your annual fees. So that one, I think it will be dealt on a case-to-case basis. So yes, so we will hopefully you've been answered. Then we'll move to the next question. Thank you.
Next in line, program director is Eldridge, then Vivian after Eldridge.
Thank you.
Eldridge, can you come through? Vivian, you may come through.
Okay, hear me? Can you hear me?
Yes.
The question is, do you need to get a contract for minor building works?
Sorry. Okay. Oh, your question is, do you need a contract for minor building works? Okay, I will go. Okay, I will go back to Rule 4.1. I'll just read it, the top part for you. But I can simply say yes, but I just want to refer to the code. Rule 4.1 of the Code of Conduct, it says that the registered persons shall ensure that before they undertake any professional work, they have to enter into an agreement with the client, and it must include the following clause. So minor building works is considered as architectural work, then it means that you will need a contract, because the code says any, even if you are giving a professional opinion on something, as long as it's architectural work, it's considered as providing architectural work, you need a contract.
Thank you very much.
Thank you.
Next in line, program director, we have Samuel, then Zachariah.
Thank you.
Hi, good day once again. I would like to ask this question. So in argument sake, let's say maybe I'm going back to upgrade I'm getting a master's, I have to write the exam again for upgrade. Then what is the process maybe from the lower category to becoming an architecture without going back to university? Thank you.
Okay, thank you so much. This will be a question that should be better addressed by our education department. So because we don't want to give you information that is wrong. So what I'll suggest is that can you please send an email to info@sacapsa.com, and then your question will be better addressed rather than being addressed by us. So it will be addressed by the people who are actually doing the upgrades. Thank you.
Hi, guys. Good day.
Yes, good day.
I just wanted to know what the SECAP is doing with graduates that are looking for mentors or any employment. Because if they don't get any mentors or any employment, they will end up practicing with illegally. Thanks.
All right. I think Kimberly is here. She should address some of the questions. If Kimberly can come in, I think that question that was not addressed earlier on, and this one.
Thank you, Advocate. I actually wanted to answer, but I wasn't sure if this was the right platform. But just to go back to the previous one, with the upgrading to professional architect without having to go back and do a qualification, SACAP does have the route, which is your recognition of prior learning process. So according to the experience that you've accumulated over a certain number of years, you can actually apply for our upgrade process through RPL. So the draftsperson would apply firstly for the next category, which is your architectural technologist. Your architectural can apply then for the senior, and so on. If you would like, I will leave my contact details in the chat just so that you can actually email me a bit later just for further information if you are interested. With the mentors, SACAP actually does have a list of practices and mentors that are interested and available to assist those candidates that cannot find work. So again, if you need any assistance, please do contact me after I drop my email in the chat. Thank you.
Thank you, Ms. Rowan. We will move to the next question, Mr. Masango.
Program Director, the next question, we've had a question from Carl. We'll allow Samuel and Zwandile before Carl again. Samuel, you may come through.
Okay.
I already asked my question.
Yes,
I already asked my question, and then Kimberly, she escalated the matter. So I will send you an email regarding for clarity for everything that I need from her. Thank you.
Thank you, Samuel.
We'll then take Mzwandile.
Afternoon again. I'm just asking, is it possible for all the categories to work like this? If it's not possible, after maybe can we able to how can it work? Because I'm looking at all these categories: the professional craftsman and professional architect technology and professional senior and architect and professional architect. When you're looking at these categories, the first professional architect can do everything that is done by a craftsman architect and goes down like that. Therefore, is it possible that can we have a rule that if you are a professional architect, you're not allowed to take the job that is done by professional craftsmen? Because if you're taking a job for professional craftsmen, that means the professional craftsmen you won't have a work at all. Is it possible to have a can apply like that on all the categories? If you are qualified to do whatever that you need to do, you have to stick to your lane. If it's possible, is it possible to to have that rule so that everyone can be able to survive on his lane, on his category. Thanks.
Okay, thank you, Zwandile. I just need to make sure that I got you. I got your comment or your question. You are saying that if you are registered as a draftsperson, you are just requesting that you should only practice what is preserved for draftspersons. Am I correct?
Yes.
Okay. Okay, then that's what we also advocate for in terms of the IDOW. That's what we advocate for, that if you are registered, sorry?
No, I'm saying that you're looking at a professional architect. He can do everything from his category up to the draftsman scope. Therefore, I'm saying if that's the case, that means the draftsman, he will not have a work at all, because if the professional architect is able to take a work that can be done by draftsmen, that means that the draftsman, you won't have a work at all in the other categories. Therefore, I'm saying, is it possible to regulate that if you are a professional architect, you only have to do this project, but you're not allowed to do the other project. Vice versa, as that if you are a draftsman, you are not allowed to do the architectural work. And can it be possible that the professional can go vice versa, can go two ways? If possible, is it possible to do like that, or to make a rule that will apply to that, so that everyone can have his portion of cake on his category? Because you find that you are not able to do, the draftsman is not able to do the work that can be done by architects, the professional architect, but the professional architect can do everything up to the draftsman, and the draftsman end up not getting work from his scope of work. Is what I'm asking.
Okay, thank you for the clarity. I will ask Ms. Klope, because I can't take all the questions. I have competent people who can address these questions. I will ask Ms. Klope to address you, Mr. Mzwandile. Thank you.
Okay, so Mr. Mzwandile, unfortunately what you're asking for cannot be done, because persons who are registered in the category of professional architect, there's competency that is involved here. They are competent to do all the work that you are describing, that persons who are registered as professional architectural draftspersons are able to do. If you look at this is more specifically related to the IDOW. If you look at the IDOW, there is a list of the qualifications and obviously the education level that is needed to render that level of work. So it's more or less us saying that if you are in that category, you should also be working hard to upgrade to the higher categories of registration, which will enable you to do more work, basically for you to be able to do more work than only being limited to doing the work that is of a professional architectural draftsperson. Because also a person who's registered in the category of a draftsperson has a certain competency, certain level of education for them to be able to do that level of work.
Okay, but I saw it's being not fair to the competition, not fair, it's only one-sided. That means you are being bullied, that you are only allowed to do this, but everyone is allowed to. I understand. And what I'm asking is, can it not be regulated that if you are a professional architect, you have to leave the work that can be done by a draftsman architect? Is what I'm asking. That if you already have, you're capable to do a bigger job, but why are you going to compete with the small fish, which he have only little work that he can get because it's restricted of this thing? I think you need to look on that thing, that if possible, because I don't think it's a fair competition what's happening. Yes, we understand the draftsman is not qualified to do that. But if the professional architect can be able to take a work for the draftsperson, I don't think it's a fair competition when coming to competition, because that's something that I understand. But I think the setup, you need to look on those things, that everyone needs to stick to his lane, and so that everyone can be able to survive.
Yeah,
it's what I'm asking.
Okay, yes, thank you, Mr. Mzwandile. We do hear your comments. Thank you so much.
Next in line, Program Director, we have two last hands. It's Elrich and Carl. In that order, please. Elrich.
Hi, good morning.
Good morning.
That was a very interesting question of the previous speaker about the category of work and stuff like that. Me myself coming from the lower level, and I've upgraded to professional architect over the years.
Yeah.
The room, especially if SACAP is driving an agenda on transformation. I think where the change can happen for lower category guys is that when this government work, the government should allow professional architectural firms to assist smaller category registration people to form part of the teams as a joint venture to also help them to understand how different building typologies work. But it doesn't have to be a law, it doesn't have to be, it is just something that I'm putting out there. But my point that I want to really raise is the problem with the Form 1, the SANS Form 1s under the Professional Code of Conduct. It actually affects the Code of Conduct for professionals submitting building plans in municipalities. Because most people only appoint us till 4.1 for municipal drawings. But you must tick every box as if you appointed till the full stages of the professional stages. And most of the times in my practice, we get phone calls from builders requesting details. In the first instance, a municipal approved plan, that's why we make it very clear in our drawings. A municipal approved plans is not meant for construction. And yet building inspectors in the country is allowing residents to build or any person to build from that approved plans without construction drawings. And that's why we find that there's so many defects in buildings because of lack of construction drawings that the architect needs to explain within construction drawings. So what we do, I was forced to put in a quality management system in my practice. And I think most people should do this to protect them from the SANS Form 1. If you only appointed me up till 4.1, this is what I'm proposing others should also do to help them. When the client come collect his building plan from you approved, we make it very clear we take no responsibility if we use our plans for construction. Because the SANS form, if you look at the Form 1 and the Form 2, the engineer ticks specifically what is appointed for. But the architect Form 1 or the architectural Form 1, you must tick every box or the municipality will not approve the building plan. And that is opening up professionals to be prosecuted or to be taken legally on. Because most of us are just taking the job to get a payment out of it, get a plan approved, but what you don't realize, you are actually responsible for that building because you tick the SANS Form 1. And then the other thing I want to ask SACAP, this is a question I want to ask SACAP. When a client, because this is what clients are doing, and SACAP need to also educate the public on this. What they do is they pay us a deposit and they pay us as per the stages. And then what they do is they sneak into the municipality and they collect the approved plans. So what I've done is I've spoken to a legal person, a lawyer. I've done it twice now where I would draw my Form 1. And as per the Act, if I withdraw my Form 1, there's no professional person over this project. That means that plan is not approved anymore. Can SACAP comment in that regard, please?
Thank you. I'll try to comment to that. I believe that maybe this is what other registered persons are doing. That when you complete Form 1, instead of putting your client's contact details so that they can be the one who can go and collect the plans neatly without telling you, you make sure that you are the one who is responsible for the approved plans, so that the municipality does not release the building plans to anyone other than you. I don't know if that have worked with other professionals, but I've seen that there are some that who are doing that the plans cannot be released to a member of the public other than the person who's listed on Form 1. Obviously, this will be different to other municipalities. So it will be interesting to know which municipality is this, so that maybe we can engage them. But thank you for the comments and the question.
The Form 1, the municipality make it very clear to us. I'm from the Nelson Mandela municipality in the Eastern Cape. They make it very clear that the property owner has the right to collect these plans.
So this will be like on a case-to-case basis. Obviously, you will have to bring this to our attention, and then we'll see how best we can engage the municipality and inform them of how clients are sneakily taking approved plan without registered persons knowing about it. So perhaps you can send us an email, because we do contact with the municipalities, so that we can raise this challenge with them and then see how best they can assist our registered persons. So you can send the email with the details, obviously, at legal@sacapsa.com, and then it will be forwarded to Mr. Masango, who is our stakeholder relation manager, and then who engage municipality on a regular basis. Thank you.
Sorry, ma'am. I think the Form 1 must make provision up until what stage is the professional appointed.
Okay.
Okay.
Mr. Aldridge, also on, I think the issue there is on the fee and when are you paid after the plans have been approved, where the client can go and collect the plans. So also on that, I think also on your agreement with the client, the method of payment and when such will be paid is quite important, because as much as SACAP is protecting the public, we also have to be mindful of our registered persons. So we have situations where registered persons will be coming to say, no, can you please assist us with my client? Unfortunately, we can't assist with that, but my advice would be that on the method of payments and when payments are made, I think that can assist you to make sure that you do not work for free, wherein after you have submitted your plans, your client goes behind your back and collects the plans, and then what else do you have? What recourse do you have? You understand? Apart from now going to attend to the small claims court, if it is indeed within the small claims court limits, or if you have to go take action against the magistrate court, or however, if it's the high court. But I think it will be on your contract and when should be, let's say if a stage is passed, do you get a fee for that? That can be arranged by you and your client to say, before the plans are approved, maybe this much must be paid, and then after the plans are approved, this much must be paid, because obviously when you submit the plans, it does not automatically mean that the plans are going to be approved. The plans are going to be assessed, and during the assessment, it can be that the plans have corrections, and you might find that maybe the client has paid 100%, and then maybe you're not picking up your call or anything. So if there are proper terms that you've agreed upon with your client to say, okay, fine, this is the process, you explain to your client, this is the process. When I draw the plans, I need this fee. When I'm done with the plans, when you sign the plans for submission, I'll need this fee. When the plans are approved, if that is the case, I'll need this fee. You understand? So
Yes.
if you can manage that part, that can at least assist. If I understood that question correctly on my side. Thank you, sir.
Okay. One last thing. Part of people submitting fraudulent building plans on people's names. Is there any way that SACAP can look in the future by giving each professional, even if it means that we as professionals have to pay for it because it's for our best interest, where we have ID cards where we present to the municipality counter when you submit your building plans, to prove that you the author of this plans and this is your registration card with your photo on. Just as a proposal, I don't know. I think it will help a lot.
Yeah. Okay, thank you for that comment. I think we have Previso that it's a live verification. So whenever you submit your plans, they can on instant they can verify if you are registered, whether you are active at that time. So we do have Previso. Obviously,
You see, ma'am, the municipalities now, they made it very clear, especially Jeffreys Bay, Nelson Mandela, even other municipalities. They made it very clear to us, they're not SACEP's policemen. So if someone submit a building plan with your credentials, they don't check it. They don't have the manpower to check it. They made it very clear to us. So that's why I'm proposing, if one have a card and then you present your card, here's my card, here's my plan. Can you please submit my plans now, because I'm the author of this plan and the registered professional. I mean, even the NHBRC with their professional engineers, they have barcodes now on their plans when they submit for registration of enrollment.
okay. Oh, okay. We note your proposal. Thank you.
Thank you.
Carl, you may come through.
Good day, guys. Okay, just another note, and I don't mean to irritate anyone again about the fees, but just on a different topic, which I have mentioned earlier. If I can just ask SACEP, to look into the different fee, SACEP fees, for the different categories, it will help a lot. And I just want to emphasize on also what Mr. Sols mentioned regarding the government jobs, is that, the draftsmen and technologists, are very much restricted, with projects, especially, with the RDP projects, that's, I haven't heard of any RDP projects, being, progressing any, well, not in my province that I can think of. But he raised also quite a few, important topics, especially when it comes to the working drawings and the construction drawings. Many do not know the difference as they, apply both, under construction drawings. And yeah, that is also a concern. So I think, there should be some curriculum training, of some sort, via webinar, Zoom webinar, to the professionals, where, the lower categories, can be informed, of the quality measures, as Mr. Sols mentioned that he applied it, in his office, which I, give 2 thumbs up, in that regard. And I just feel, with the candidates, registration, there are so many out there that are, addressing clients. I can't prove it, as much as I want to. There are many of them that I know of, but I can't prove it. I can't give evidence, that they are doing it. But they are, engaging with clients, and they, they're providing a professional service. Now, that, like I say, you can't give evidence, but I sincerely think SACEP should, bring, some form of strategic ways, to find, to bring that under control. Because that takes food off the tables of the registered professionals that are really trying to be professional. And if I got this correctly, if it is the same results that I know of, I think we've come across each other quite a few times at the Nelson Mandela Bay municipality, and we both addressed the same issues. That there are some flaws. I'm not saying it's SACEP's fault. I'm just saying SACEP, should find strategic ways, in order to implement like a policing or some kind of method to grab this, and to get, control within the professionalism of the SACEP. And I think that's a big concern at this current moment.
No, we thank you. We thank you, Mr. Kai, for the comments and for the suggestions. We are noting them, and then we will refer them to the relevant personnel. Thank you so much.
Program
Gates.
Director, we still have two more hands. You will guide me if time still allows to allow the two attendees.
Yes, I think we can take the last two. Thank you.
All right. We'll have Clement, then Stanley. In that order, please.
Hello? Hello?
Hello? Yes,
Can
yes,
you
we
hear
can
me?
hear you.
All right.
Yes.
Okay, just sorry for the previous interruptions. I had my speaker connected to the speaker, so it couldn't be heard. All right, I would just like to bring up the issues of registered candidates and some of the other connected issues that have been mentioned by the previous speakers. I do think that the registered candidates, the way the candidacy is structured needs to be reimagined, especially with the economic climate and work not being available. Because if professionals are crying about not having work, how are candidates supposed to fulfill their candidates' mentorship? Because if professionals are saying they're not getting work, how are the candidates going to go into the system? I think this also filters down to the issue, I think it was mentioned by Carl, that they find that there are candidates who are taking work which is supposed to be done by professionals. This will be the case because if work is not there, that means professionals are not even obliged. I think I checked the CPD, there is not even encouragement for professionals to mentor. It's not an obligation. And there aren't sufficient points to even encourage them to keep mentoring. So you will then find that there is a practicality that people need to survive. As much as SACAP exists and they regulate and candidates are not supposed to take work or do that sort of thing, that means they will die after having spent so much money in universities to study, and then they come out and the profession they find is close to them. So I think SACAP needs to reimagine how candidates are able to get work. That will also limit candidates going out illegally and getting work for themselves. It will work together with the professionals if also the professionals, they open up to mentor more and be more creative, because it's possible candidates know people as well. They are part of the community. Someone will approach a candidate who's studying architecture. They have no idea how it works. So the candidate should be able to refer the client to a professional. And then that professional provides the mentorship for the professional so that the professional takes responsibility for the work. At the same time, the candidate gets employment, they are able to be mentored and they continue. But the way that is structured at the moment is what is actually causing the issues. I would like to also just touch on, I think what could also assist that is what I refer as multiple mentors, because it seems at the moment that a candidate is limited to have one mentor and they are not able to register also without a mentor. So if a professional does not have work, then it's a problem for the for the candidate, because then they can't continue and they are stuck with that mentor. So I think a multiple mentor system is needed. The other issue is fees. Candidates need to pay fees as well to be registered. It's not free. And I don't think that is really just. However, it is what it is. But you need to think about it, that this is someone who is not employed or who is employed and earning very little. If professionals are crying, then candidates don't have the money. So it needs to be reimagined how it can be best suited for candidates to be able to pay fees. I think you have now, before it used to be 2 years. And now I think you take it up to 4 years or so, where a candidate needs to remain a candidate before they are forced to register. I think that needs to be reimagined, because if a candidate does not have work, they still need to pay the full year. But in that year, they could have only been employed for a quarter and then they lost the work and then they can't continue the mentorship. Yet the annual fees are due for the entire year. That is not fair. So I think it needs to be reimagined that they are candidates. They are still learning in the profession. Maybe it should be based on a monthly basis so that it's proportional. If a candidate only gets work for 3 months, they should only pay for 3 months, not an entire year. I would mention that I was tied down in the mentorship system for a very long time, from 2006 of registering until 2012, where I had to fork out work. I had to even volunteer with a number of architectural professionals. That is not fair. SACAP needs to reimagine this, please. Reimagine it. Think about candidates. They shouldn't be made to cough out money because SACAP is benefiting from the money on an ongoing basis, but the candidates are not moving up the ladder. So I think SACAP needs to live up to their expectation that they say they are people-centered and think about the people and be fair on the people and the money that they cough out for the even the annual fees that they're talking about. On the last one, okay, I think I covered some of the things and so on. Yeah, well, entrepreneurship. So I think that also needs to be imagined a bit. We are living in an entrepreneurship time. So I think entrepreneurship needs to be encouraged. I don't know whether at an educational level or at a candidate level, so that people get ready to create jobs and also be able to create employment within that. So people shouldn't be stuck as candidates forever. Professionals as well should not feel that unregistered people are taking work from them and so on. And this will continue. I will tell you because I'm on the ground. I'm not sitting at a fancy office somewhere out there. I live with all these people. I know people have to survive. So they will take work illegally until SACAP changes and opens up the market and reimagines how things work, because people need to survive. Saying that people shouldn't take work illegally, how are they going to put food on the table when they are stuck for 6 years in mentoring? I was stuck for 6 years. And then after that, SACAP did not allow me to write the PPE. They took all the money, and it's only after some time that's going to happen. That's not fair. So I'm being honest here. Don't feel that I'm being rude or anything like that. I'm being honest. SACAP needs to live up to the transformation agenda and show us as architectural persons, all people, professionals, unregistered people, candidates, so that SACAP becomes a better profession for everyone. Professionals will be happy, candidates will be happy, and unregistered people will likely register. If you treat them properly, you don't put fees ahead of people. You put people first, as you say, you are people-centered, and then the fees come. We will have money. The money will be shared amongst all professionals, whether it's architects, senior architectural technologists, and draftspersons. And the IDOW, I agree, it is unfair because you pay annual fees that are the same as an architect. If you're a senior technologist, you are a technologist, you are a draftsperson, you all pay the same fee. But the architect at the top can do any work, even work that can earn millions, yet they are paying the same 3,700 or something for the annual. And the draftsperson who's limited to a single story is paying 3,700. Yet the other one is earning $1 million. The other one is only getting maybe 10,000 rand on some additions and alterations. That's not fair. Thank you very much.
Okay, thank you. Thank you so much. Thank you for your comments. Due to the purpose of time, because our webinar it's supposed to be from 9 up until 1, we actually have 3 minutes left, which means we are running out of time. But thank you so much for your comments. We will take, we are taking notes. For the purposes of our program, we will hand over to the registrar for vote of thanks and closure. Thank you. Registrar?
Through you, program director, before registrar does the closure, to the attendees, ladies and gentlemen, we kindly request you to participate in the survey that will be on the browser right after the end of this webinar, and will also be sent to your emails at the conclusion of this webinar. So your valuable insight will greatly assist us in better understanding the challenges you face and allow us to tailor our future initiatives to your needs. So your feedback is integral to our continuous improvement efforts. The questionnaire will be right at the end of the webinar and will also be emailed to your email addresses. Thank you. Over to you, Program Director.
Thank you. Thank you so much. Yes, I'll hand over to the registrar to close. Before I hand over to him, I just want to thank you all for allowing me to be your program director today. I feel honored. Thank you so much for your attendance, and thank you so much to all the panelists. Thank you for your comprehensive presentation. I believe that it have assisted our registered persons. They will better conduct themselves in future. From here going on, they will have written agreements in place. They will know what to do and what not to do. Thank you all. Thank you.
All right, thank you very much. Let me appreciate all the registered persons that attended today. I hope that the workshop was useful to you and you'll go back to your practices and implement all the things that we've discussed today. We've also noted all the suggestions that have been put forward. The team has noted all those suggestions. We will note them and be able to go back and review our way of doing things and improve. Let me also thank the team under KG, Kaukelo, that prepared for this webinar. You guys have done a good job. Let's continue working with the professionals. Let's continue helping them so that we can reduce the number of complaints that we are receiving. We don't want to find ourselves all the time using a stick, to professionals. We want to find ourselves working with you to protect the profession and also protect the public. So thank you very much. I hope that you will take your time to answer the questions that you're going to receive as soon as we end here, and then we'll automatically receive all the responses. Hopefully we'll engage again in the near future to educate us ourselves about the code of conduct. Thank you very much.